Welcome back, students. This is lecture 3 of Law and Ethics, Indian Contract Act 1872. Right, so we have started with Indian Contract Act 1872. This is the third lecture, and this is for CMA Intermediate June 2023 attempt. Okay, so let me take you to where we ended last time. Right, so this is where we had ended. Okay, so we are basically seeing who is disqualified for contracting. Okay, who is not competent to contract. So the third one was other disqualified persons. So before that, I'll just show you. Here, okay. So we were doing this, which is constraints to enforce contractual obligation. That is competence to contract or capacity to contract. Okay. So this is who is competent to enter into a contract. Okay. So कौन contract कर सकता है और कौन contract नहीं कर सकता कानून में. ठीक है. So here, Alan, please go on mute. Right. So who is competent to contract? Okay. So general thing was that the person should be of the age of majority, 18 plus years. Okay. 18 years or more, sound mind, and should not be disqualified from contracting. So these 3 points which you are seeing here, that is what we were examining. Okay. 1, 2, and 3. Okay. So what does this mean is these 3 points that these people are not competent to contract. Who? Minor is not of the age of majority, person of unsound mind, and person who is disqualified from contracting by any law. Okay. So this is who is competent to contract. Okay. This is the thing which can be asked. It is asked several times. Okay. It's a very important question. Competent to contract, very simple, right? So for minor, what we had seen, not attained the age of 18 years. Okay. But if a guardian has been appointed, for minor, if a guardian has been appointed under the Guardians and Wards Act, okay, you need not even mention the year. Just say Guardians and Wards Act, that is sufficient, right? And whose property is under superintendence of any court of wards. Okay. So before he attains 18 years, okay, if a guardian has been appointed under Guardians and Wards Act or his property is under the superintendence of court of wards, then his age of majority is not 18 years, it is 21 years. Okay, right? So this is what you have to understand. यहाँ पे हमने क्या देखा है? 3 चीजें हमने देखी कि people who are not competent to contract, ये 3 होते हैं. Minor, person of unsound mind, disqualified from contracting by any law. Okay, minor is below 18 years. Okay, और इसमें ये एक पॉइंट इंपॉर्टेंट है जो आपको याद रखना है, that if a guardian has been appointed under Guardians and Wards Act, okay, अब वो guardian appoint होना चाहिए 18 years के पहले. Okay, then the age of majority will be 21 years. Okay, one more thing is someone whose property is under the watch of court of wards. Okay, तो ये बस ये 2 चीज एक्सेप्शन है इसमें. ठीक है, right? So then so this first thing what we saw is minor, second was person of unsound mind. Okay, now these points we have already covered in last lecture, so I'm not repeating this. Okay, so here next is sound mind person. Sound mind person is the he should be capable of understanding and forming a rational judgment. Okay, he should be capable of understanding and forming a rational judgment as to its effect upon his interests. Okay, right? So this is called a sound mind person. So this is what I told you. Sound mind person is not just a lunatic as we normally understand. Okay, it can also be someone who is of very old age, who is sick. Okay, or who is under the influence of liquor, and he has made a contract during that time. Okay, so once it happened in railways. Uh, my dad was in railways. It once happened that there was a clerk. Okay, so he had some delirium. He was a pay clerk at that point of time. Everyone used to get paid in cash. Okay, they would go to the pay clerk and get paid in cash. He had some delirium that he just took all money and he started just distributing it. Okay, so that is something which happened. Okay, other people were good enough that they all returned it back. So which is why a sound mind person doesn't always mean a lunatic. Okay, I mean, sound mind doesn't always mean, unsound mind person doesn't always mean a lunatic. Okay, he is someone who is not capable of understanding the contract and forming a rational judgment. Okay, in the instance I told you, he couldn't form a rational judgment at that point of time. Okay, so this is sound mind persons. Two people who cannot contract, we have seen minor sound mind person, and this is where we had to continue now. Okay, so this is the third thing, which is other disqualified persons. Okay, so these people are disqualified from contracting. The law disqualifies them from contracting. Okay, so in disqualification can be due to legal status, political or corporate status. Okay, let's see. So legal status, example for legal status is alien enemy. So if our country is in war with some other country, okay, you cannot have a contract with that country. Okay, so if the government permits, you can have, otherwise you cannot. You can ask me, why would the government permit a contract with an alien enemy? Okay, alien here is not someone who is not of earth. Okay, alien here means someone who is not of our country, a foreigner. Alien is equals to foreigner. Okay, right? So when can a government allow it that you can have a contract uh, with a country with whom we are at war with? Okay, so that can happen when there is a humanitarian issue. Say you are in war with one country and there is some humanitarian issue over there. Okay, and lots of people are dying or something, and you are a company who can provide medicines for that. So the government might allow it even if it is on war. Okay, so for other disqualified persons, one is alien enemy. Okay, and any, if you already have a contract with a foreign country, someone in foreign country, and then war starts, then that contract is suspended till the war ends. Okay, and once the war ends, it can restart. So this is first thing which we saw, legal status, disqualified due to legal status. Next is political status. So political status, best example is foreign sovereigns and ambassadors. So ambassadors have what is called as diplomatic immunity. Okay, so they have diplomatic immunity. Okay, diplomatic immunity means that they can uh, they cannot enter into contract with anyone in India. Okay, same in any other country, because our ambassadors also are there in other countries. Okay, so I am telling you from Indian point of view, right? So they enjoy certain privileges and immunities in every country. Okay, they are incompetent to contract. Actually, they cannot enter into contract. Okay, except through their agents. Okay, they can only contract through their agents. They can sue Indian citizen, but an Indian citizen cannot sue them. So if an Indian citizen cannot sue them, why would you enter into a contract with them, right? Because there you don't have any legal remedy against them. Okay, so which is why foreign sovereigns and ambassadors are someone who have some special status. Okay, because of which they are incompetent to contract. Okay, so and last one is, so legal status we saw, alien enemy, political status, okay, we saw, and then corporate status. Okay, so okay, and corporate status. So these are the three things. So here, if you see, so actually here, actually speaking, this order, okay, it is political status is your alien enemy. Okay, this is your political status. Okay, legal status is your second one, which is foreign sovereigns and ambassadors. Okay, and then last one is corporate status. Now, why corporate status? Corporate means companies, right? So companies cannot do anything which is not in their memorandum of association. So here you can see this is your company or statutory bodies. Contract is valid only to whatever is within the memorandum of association. Okay, this is the limitation. And here there are two more points for after foreign sovereigns and ambassadors, and you have convicts. Okay, a person who has been who is under imprisonment, he cannot contract. Okay, he cannot contract when from the moment uh, imprisonment has been declared. So he need not enter the prison. Okay, the moment imprisonment has been declared by the judge, okay, till the end of sentence. Okay, till the end of sentence. Till this time, he is incompetent to contract. Okay, fine. So, and then last are insolvent. Once a person is insolvent, an insolvent actually is a zero at this point of time. Meaning of insolvent is he is at the moment he was declared as insolvent, he is zero. Okay, he has no assets, no liabilities. Okay, so if he enters into a contract, what will he give? Right, he has zero assets, he cannot give anything. Correct. So insolvent person is the one who is unable to discharge his liabilities and has been applied to be adjudicated as an insolvent. Okay, so there are stages in insolvency. So either he has applied to be adjudicated as an insolvent, then he would be adjudicated as an insolvent. Once after he has applied, next is the law will adjudicate him as an insolvent. Okay, there will be two stages. But once he has applied for being an insolvent, from that point of time, he is not competent to contract. Okay, and these proceedings can be initiated by his creditors also. Okay, so creditors also can. Why creditors initiate it is, say, for example, he has his total money is, let us say, 10 lakhs. Okay, and now creditors know that his debt is, let us say, 20 lakhs. Right. So if they continue to allow him to work, this 20 lakhs might reach 30 lakhs and they will get even less. Correct. So which is why, to stop him, creditors also sometimes can bring in a petition, okay, for him to be called an insolvent. Okay, fine. and then कंपनी. ओके, दिस इज ऑल्सो. ठीक है, तो यहाँ पे मैंने 5 एग्जांपल्स आपको बताए हैं अदर डिस्क्वालिफाइड पर्सन में क्या क्या हो सकता है. इट इज डिस्क्वालिफाइड ड्यू टू लीगल स्टेटस, पॉलिटिकल स्टेटस और कॉर्पोरेट स्टेटस. ठीक है, कौन सा है ये बताने की आपको जरूरत भी नहीं है, बस एक सेंटेंस लिखना है आपको कि लीगल स्टेटस, पॉलिटिकल स्टेटस एंड कॉर्पोरेट स्टेटस. ओके, एंड देन you will have to just enlist these examples. ठीक है, एक हो गया alien enemy, second is foreign sovereigns and ambassadors, then convicts, insolvents. ठीक है, and company or statutory bodies. ठीक है, ये 5 इसके एग्जाम्पल रहेंगे आपके. फाइन, इस तरह से we have finished who what is competence to contract and who is not competent to contract. ये 3 were not competent to contract. Okay, fine. So now next part which we are going to do is consent. Okay, so consent means when two people are say before doing something we take permission of certain people. Okay, when you take permission, if he says yes, that is said to be consent. Okay, in Hindi we call it हामी. Okay, so here, so two or more persons are said to consent when they agree upon the same thing in the same sense. Okay, so many times it happens that you some other your colleagues are chatting say, close to you. Okay, whatever they ask while in the course of their chat, sometimes they ask you something, right? Ki, something like, okay, this isn't it, or something, and you are in your home, you just say yes, yes, you just go on saying you don't focus on them, but you just say that doesn't mean you have consented. Okay, right? Because you are uh, you are not agreeing upon the same thing in the same sense. Okay, right? Because your mind is not in what they are talking. I'm just giving you a general example which happens in our daily life. Okay, happens with everyone. Many times we study, and then our mom or some younger brother, younger sister, whatever, okay, they go on talking something about their stuff. Okay, and you are doing it, you just say ha, you just continue to say, right? This is the best example of same sense. Okay, so this is basically same sense. Okay, that is the meaning of same sense. So you should actually, if you are agreeing to something in a contract, this is social, what I told you is social, but in a contract, so both of you should agree on the same thing in the same sense. Okay, right? In comedy movies and all, most of the premise is like that, that if there are say, two comedians, one will talk about something. Okay, the other person will think about something else and then he will agree. Okay, and that becomes a comedy. Okay, something like that. So now consent is very important in a contract. Okay, extremely important. So let's go ahead and see. If not, okay, then no contract is formed. If there is no consent, there is no contract. Okay, it's so important. Okay, your contract itself falls flat. ठीक है, तो ये है आपका कंसेंट. अब इसको एग्जामिन करेंगे, ये बहुत इंटरेस्टिंग पार्ट है. ओके, दिस इज वेरी इंटरेस्टिंग. सो इन कंसेंट, one thing which we talk about is free consent. ठीक है, हम बोलते हैं फ्री कंसेंट. ओके, so free consent is very, even in consent, okay, the consent should be free. That is very important. That is, nobody should have forced it on you. Okay, ठीक है. So let's see. Now consent is said to be free. Consent is said to be free when it is not caused by. ठीक है ना? अगर कंसेंट कब फ्री है, जब इन 5 चीजों से कंसेंट नहीं लिया गया है. ओके, कंसेंट is free when it has not been taken using any of these 5 means. Okay, what are these means? One is coercion, so we will discuss each one of these separately. Undue influence is the second one, fraud, misrepresentation, and mistake. Okay, so these are the things which should not affect a consent. If any one of these affects a consent, it doesn't remain a free consent. Okay, so let's now examine each of these one by one, starting with coercion. Fine. Now uh, this is a flow chart which has been given in your study material. Okay, we will come to it later. Let's finish this topic and then come, because in this flow chart there are many words which we have not discussed so far. Correct. So once we finish it, I'll just bring you back to this chart. It's a good chart. Okay. So now let us go ahead with the topic. Now, first thing is what? Coercion. Okay. So consent is said to be caused by coercion when it is obtained by committing or threatening to commit any act forbidden by the Indian Penal Code. Okay. So Indian Penal Code lists all acts which are crimes, considered as crimes. What is forbidden by Indian Penal Code means you are doing something which is unlawful. Okay. So you are committing or threatening to commit anything forbidden by the Indian Penal Code. And then next is unlawful detaining or threatening to detain the property of another person. So now in short, what you can say is, by wrong means, okay, if you want to cause a consent, if you want to cause a consent and you are threatening, okay, either to detain the person or property of another. This is how you can in short say. Okay, this is like threatening. Okay, threatening to detain, okay, or to commit something on the person or property of an individual. So you are kind of trying to injure him in some way. ठीक है? ओके, तो कोवर्शन क्या है, मैं हिंदी में भी आपको समझा देता हूँ एक बार. ओके, ये कोई भी चीज है, आप बिजनेस में आप कंसेंट जबरदस्ती लेना चाहते. ओके, जबरदस्ती लेने के लिए आपको क्या करना पड़ेगा, यानी basically you can just use the loosely you can use the word blackmail. Okay, we are kind of blackmailing him. क्या करके आप blackmail कर रहे हो? That you will threaten, okay, either his person or his property. His person यानी वो भी हो गया, उसके relatives भी हो गए, right? Many times people kidnap children and all that. That's all coercion. ठीक है? Use of force. Coercion, among all the 5, in coercion you will find use of physical force. ठीक है? तो जब coercion यूज होता है ना, तो गुंडों का यूज होता है. ओके, इट इज यू यूज goons. Okay, you use goons. Give me just 1 minute. Okay, so so इसमें जो है basically it is kind of physical, you can see. Okay, right? And consent is said to be caused by coercion if obtained by, if you are committing or threatening to commit any act forbidden by the Indian Penal Code. That is, you are saying I'll kidnap or blackmail, anything like that. Okay, which is forbidden by law. And second is you are unlawful detaining or threatening to detain property. Okay, you are just, it's many times happens, right? Um, some goons and all, they take control of somebody's flat. Okay, so something like that. Okay, so it can be, they can basically for coercion they can use either your person or your property. Fine, right? Yeah. So now coercion may come from a person okay, party to the contract or even third person. Okay, most of the times it is initiated by party to the contract but comes from third person. Okay, coercion is done by professional goons normally. Okay, so it mostly comes from third person, or although it is initiated by a party. Okay, fine. Here we have said that forbidden by the Indian Penal Code. So what if a person is not residing in India? Okay, and from there he has committed an act of coercion. It's possible, right? Someone like in India, most of the illegal activities were committed by Dawood, right? So, and he was not in India, correct? So it's possible that someone outside India can cause the coercion. Okay. So if now we are talking about Indian Penal Code, then wherever Indian Penal Code doesn't apply, Indian Penal Code applies only in India, right? If it doesn't apply, then what will happen? Okay. So that's why this explanation has been inserted. Okay. It is immaterial whether Indian Penal Code is or is not enforced in that place. So you will just say if there is someone outside India, okay, he has committed coercion. Okay, outside India person, he has committed coercion. Okay, so what you will see is you will measure this act. Okay, you will just see whether if this act was committed in India, if committed in India, would it have been coercion or that is how you will find out. Okay, so even if it is outside India, okay, you will just consider as if this has happened in India and Indian Penal Code applies. So will it be a coercion or not? That's how you will interpret it. Okay. So this is coercion, the first thing which causes consent not to be free. Okay. Coercion is the first thing. And just remember, in coercion, you will have use of force. That crude physicality is there in coercion. In the other four, it isn't physical. Okay, it's like nobody is like harming you physically or okay, things like that. So these are different various ways under which pressure is brought upon you. The next is what? Undue influence. Okay. Contract is said to be induced by undue influence, where the relationship between the parties are such that one party is in a position to dominate the will of the other and uses it to obtain unfair advantage. Okay, fine. So, here in undue influence, there are two people. One person is in such a position that he can dominate the will of another. Okay. For example, many examples you will get. One is doctor and patient. Okay. Doctor and patient. Right? Doctor can tell the patient, oh, he can say he has done some X-ray or anything. He sees, he says, oh, that is a big problem. You will have to get into a treatment. Just deposit 25,000. Otherwise, you might have a problem. Okay. It can threaten your life. Okay. As a doctor, look. And normally तो जैसे इंडिया में डॉक्टर्स ऐसे नहीं करते हैं ओके दे माइट चार्ज मोर ठीक है दे माइट चार्ज मोर बट दे नॉर्मली डू नॉट show an ailment which is not existent. Okay, normally it doesn't happen, but people do these things also. Okay, so इस केस में अभी पेशेंट को क्या समझेगा बताइए पेशेंट will not understand that what his ailment is and okay he would be frightened when the doctor says that there is some big problem or something. So what he will do, he'll just arrange for the money and give it. Okay, right? So this relation, doctor and patient, is something where the doctor can have undue influence on the patient. Okay, this is where doctor can have an undue influence on the patient. Okay, there are many such relation where one person starts as a big brother basically. Okay, and the second person he can you can have an undue influence on the other person, right? One more is like your lawyer and okay, lawyer and uh, okay, what is it called? Like, so lawyer and the person who has approached him for a case. Okay, so the person approaching for a case. Okay, right. So lawyer. So if lawyer says if there is something, someone has put a case on a person. Okay, so here basically it's a client. So that's what I was missing. Okay, so lawyer and client. Fine. So so this person says somebody has put a case on him or something. Okay, sued him basically, right? So the lawyer might say that okay, no, we will do this. Then only then it will be okay. Otherwise, he can do this something you can show him, right? Because the client doesn't know the law. So here there are people, okay, who have superior knowledge of a subject, because of which they can have undue influence. Okay, so this is called as undue influence. And okay, first thing is he is in a position to obtain unfair advantage because of his position. Apart from the above, okay, a person is deemed to be in position to dominate the will of another, fine, where he holds a real or apparent authority over the other, or where he stands in fiduciary relationship to the other. Okay, where he has real or apparent authority, is some sort of a manager and employee, right? Manager can exert undue influence on the employee. Okay, there are many things. And where he stands in a fiduciary relationship means a relationship of trust. For example, a trustee. So the beneficiary will try to have good relationship with the trustee, because he will always think the trustee has powers to harm him. So such relations are called fiduciary relationship of trust. Okay, and where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reasons of age, illness, mental or bodily distress. Okay, so you can say kind of uh, doctor, nurse, okay, someone who is treating some other person, okay, who has no one to help. So he is in a position to take advantage of, right? And there's one more thing is where a person is in a position to dominate the will of another, enters into a contract with him, okay, where a person in a position to dominate the will of another enters into a contract with him, okay, and the transaction appears to be unconscionable. That is, it is appearing that he has taken, say, for example, there's a nurse who is treating a very old man, and he has collected some 50,000 from him. Okay, and if you ask him what that 50,000 is for, he is not able to explain. So that is the meaning of transaction appearing to be unconscionable. Okay, transaction appears to be unconscionable. Okay, if this happens, the burden of proving that there was no undue influence lies upon the former, that is in this case the nurse. Okay, so there is a presumption of undue influence in these cases. So you start with the presumption of undue influence in these cases. Okay, what are these? Parent and child. So here in India, it's not prevalent, okay. But in foreign countries and on many times, children complain against parents. They call their number, okay, whatever is the police or whatever. They call them and they can complain against the parents, saying that I have been hit or I am not allowed to go out. Okay. So these are the things. So here, if that in India, that doesn't happen that much, right? So, but in a parent and child, if a child complains, then what will be the presumption to start with? You will think that, okay, parent has done that. Okay, you will start with that. Parent will have to prove that what the child is saying is wrong. That's called as presumption of undue influence. Presumption means if you have two parties, you are not starting at 50-50. Okay. So you are in favor of some party more. That is called presumption, where you are presuming someone to be right and someone to be wrong. Okay. So in this case, there is a presumption of undue influence. Parent and child, guardian and ward. Guardian and ward is same as parent and child. So if say that a child doesn't have parents and he is being brought up by a guardian, then the child will be called his ward. Okay? So it is called as ward. So guardian and ward, same as this. Okay. Then doctor and patient, solicitor and client. These two examples we have discussed. Trustee and beneficiary. This is that fiduciary relationship. Okay. Religious advisor and disciple. So Babas and all, they're going for something, they say that no, you have to do this puja, otherwise something bad will happen. So people who trust them, okay, they will be ready to spend any amount of money. Okay. And this is, okay, fiancé and fiancé. Okay. So this is basically two people who have been engaged. Okay. Fiancé and fiancé. So both pronunciations are same actually. In this, this one has one E more. So this is for the female. This is for the male. Okay. So this is like two people who are engaged to marry. Here also there is undue influence is presumed. Okay. So in all these cases, undue influence is presumed. Now, there is no presumption of undue influence in these cases. So landlord and tenant. Okay. So these are basically seen as relationship of equals, landlord and tenant, debtor and creditor. Okay. See your fiance, fiance and fiance, this thing. Here presumption is that of undue influence, but husband and wife, there is no presumption of undue influence. Okay. Right. So in bracket they mentioned if wife is not pardanashi. Okay. If wife is pardanashi, that is wife is on parda. She doesn't talk with other people and all. Okay, openly. So in that case, there is a chance that the husband can exert undue influence, right? Because she doesn't know the outside world well, right? So if wife is pardhanashin, then there will be presumption of undue influence. But if she is not pardhanashin, for normal wives, husband and wife, there is no presumption of undue influence. Okay. So in these relationships, okay, undue influence has to be proved in these three. You don't start with the presumption. Okay. Now, two elements are found in undue influence. Okay, this is just summarization of what you have learned. But this is the best part. If this thing you understand, just remember this thing, it's good for whole undue influence. Okay. One party is in position to dominate the will of other, and he uses it to obtain unfair advantage over the other. That's it. This is undue influence. Okay. To avoid the contract on the ground of undue influence, must prove both elements. Okay. You have to put both these have to be proved to avoid the contract. Okay. So here there are some examples. Okay. Here there are some examples. So what is the first one? A having advanced money to his son B during minority. Okay. He advanced money during minority to his son. Upon B's coming of age, now B has become an adult. He obtains by misuse of parental influence a bond from his son B for a greater amount. So this is undue influence. Okay, because there is a possibility that sometimes, normally see in these relations it doesn't happen, but just for the law, and maybe there's some rare cases where you can see this. That there is misuse of parental influence and you try to get some money. Okay. So sometimes this also happens that, here you have a son. Okay. Son. And here say you have your mother, and here you have wife. Okay. So now sometimes it happens that, one of these parties, they do not want more property to go to the other. Okay. So they can just emotionally blackmail and get him to give a bond or something like that. Okay. In that case, there will be undue influence. Presumption will be there. Okay. So that is this example. The next is man enfeebled by disease or age. Okay. Very old man. Okay. He is induced by uh, B's influence over him as his medical attendant. So B is his medical attendant, and he agrees to pay B an unreasonable sum for his professional services. So B is just, asking him to pay an unreasonable sum for his professional services. Then it is undue influence. Okay. So now he has nowhere to go. He's diseased person or very aged person. So he is talking to him regularly, and there's possibility that he is, in the way he speaks, he is asking the old man to give something unreasonable. Okay, and he does it because now he is the only person who's coming and helping him. This nurse, he doesn't want him to go also, right? If you're helping someone, doesn't mean that you take advantage of them, isn't it? So this is also undue influence. Next is A being in debt to B, the money lender of village. We are also money lender. Okay. So A has taken a debt from the money lender. Then he contracts a fresh loan on terms which are not conscionable. Okay. That means, say he's taking a loan on a very high rate of interest or something from the money lender, and he's already in some debt with him. Then it lies on B to prove that contract was not influenced by undue influence. Okay. In these cases, because now the money lender, it will be uh, thought that the money lender is in a position to exert undue influence. That is why the other person has taken a debt on a very high rate of interest. Fine. Then next is banker. Okay. So here it says A applies to a banker for a loan when there is financial stringency in the market. Okay. The banker declines to give the loan except at an unusually high rate of interest. A accepts the loan. This is not undue influence. Why? Because it is usual thing of banking that whenever people are in real need of money, they will raise their interest. Okay. If people are in real need of money, what will they do? They will raise their interest. Okay. It's basically demand and supply. More demand of their loan, the more they will raise their interest. Okay. So which is why this is not undue influence. This is business. Okay. This is normal business. So then effect of undue influence. So we are now going to see what is the effect of undue influence. So if there is an undue influence and it is proven, the agreement is voidable at the option of the other party, so whose consent was so caused. Okay. So it is voidable at the option of the aggrieved party. If the aggrieved party seeks to rescind the contract, he must restore the benefit upon such terms and conditions as court may seem just. Okay, so if the aggrieved party wants to rescind the contract, that is, he's saying that I want to cancel the contract, and he can cancel it. But if he has taken anything from the other party, okay, then he will have to return it. Fine. So here again, a couple of illustrations we will see. Okay. Now A's son has forged B's name to a promissory note. Okay. So A's son, he has forged B's name in a promissory note. Now what B has done, under threat of prosecuting A's son, he obtains a bond from A for the amount of the forged note. Okay, understood. What has happened here is we have A. Okay. Okay. A and so A, B, okay, and we have A's son. Okay. Now A's son has taken, what A's son has done is he has forged the name of B in a promissory note. Okay. So now what he has done is, now B came to know that, let's say he has forged about say 10,000 or 50,000. So A has come to B has come to A. A is that your son has forged some money from me. So you pay me the amount. He has threatened him. But I will, I will make use of this, or maybe I'll just tell everyone and all that. He has threatened him that you sign a bond, otherwise I will either take legal action or I'll do something. Okay. So A has now signed a bond. So here what has happened? It's pressure on A, right? Actually, now if everyone are adults, if A's son has forged something, B has to take it from A's son only, correct? Now, if he's going to A and he's saying that, okay, he's threatening to do something, and because of threatening, he is getting a bond signed. So that is nothing but undue influence. Okay, that is nothing but undue influence. So, which is why this is the case of undue influence. Okay. So, right. So then court can, if now B has the bond, correct? B has the bond. If he goes to the court suing on the bond, then court can set the bond aside. Okay. Because it has been obtained by undue influence. Now, next is a money lender advances rupees 100 to B. Okay. A is a money lender, advances 100 rupees to B, an agriculturist, okay, a farmer. Okay. And by undue influence, induces B. So B is a farmer, A is a money lender, he has given 100 to the farmer. Okay. And by undue influence, induces B to execute a bond for 200 with interest of 6% per month. Okay. 6% per month is a very high interest. Okay. Annual interest is 72%. So the court may set the bond aside, right? Because he has already taken some money. On the strength of it, he is trying to enter into another contract which is not conscionable. Okay, right? So court may set the bond aside and ordering B to repay 100. B is the farmer. Farmer has taken 100, so he has to repay it, correct? So repay 100 with such interest as seems just. Okay. Court may direct the aggrieved party to return the benefit either in whole or in part. Okay, court has the power to tell him whether he can return 100 more, or his condition is not that well, that good. So court can ask him to return a lower amount. Okay, right? So, or it is also possible, like if it appears proper to the court, it can also say that you need to pay nothing. Okay. So this is it. But when you answer these questions, okay, you do not have to give these things. Okay. You just have to say that court may set the bond aside, ordering B to repay 100 which interest as it seems just. Okay. The further powers of the court, that is not too much relevant to us. Okay. So if you remember, you write, otherwise that is fine. You just have to examine whether it is undue influence or not. So now, to avoid a contract on the ground of undue influence, the plaintiff has to prove that. Okay. So plaintiff and defendant are the two parties, correct? So plaintiff is the complainant, okay? And defendant okay, plaintiff and defendant. Okay, the plaintiff is the complainant. Okay, and defendant is the person who is defending the complaint. Okay, so basically this person has sued. Okay, the plaintiff has sued and now defendant is defending himself. Okay, this plaintiff and defendant. So to avoid a contract on the ground of undue influence, plaintiff complainant has to prove that the other party was in a position to dominate his will and he actually used his influence to obtain plaintiff's consent. Okay, these two things have to be proved. Okay, see, in reality, there will be many people who are in a position to dominate someone's will. It doesn't mean that they have used undue influence. Correct? Fine. So, the plaintiff, so who will complain? The person who is aggrieved, who is saying that he has used undue influence on me. But if he is complaining, he has to prove these two things. That other party was in a position to dominate the will and he actually used his influence to obtain the plaintiff's consent. Okay. And the defendant has to show that plaintiff has freely consented. That's it. Fine. So further presumption of undue influence. Okay, it is there in unconscionable bargains, where you think that there is something not correct in it, where the law thinks that there is something not correct with a particular bargain. Okay. And contracts with Pardanashin woman. Okay, you have a presumption, you start with a presumption of undue influence, apart from what we have discussed above. These two are there. Fine. So we have finished what? Coercion and undue influence. If these two are present for taking consent, then it will not be a free consent. Okay. A third thing is fraud. Okay. Now fraud is very close to coercion. Okay. Only thing is that the physical part is not there. There's no goon or someone who is coming to threaten you and all. Okay. It is like it is like the person who is defrauding you will look like a gentleman, basically. The way he will dress up, the way he'll appear, okay, will not know that he is defrauding you until he has actually defrauded you. Okay. So now here, fraud, acts committed by a party to the contract or with his connivance. Okay, connivance means in Hindi you call it mili bhagat. Okay, so basically he is colluding with someone else and doing it. Okay, acts committed by parties to the contract or with his connivance or by his agent with an intent to deceive another party, his agent, or to induce him to enter into contract. So here the thing is intent to deceive. You are doing something to deceive. Okay, that is called as fraud. In fraud, there will be no physical element. Okay, it will all be, it is basically kind of a white collar crime. It is a white collar crime. Okay, that's the difference between your coercion and fraud. Okay, so So basically, acts committed to deceive another person. In short, you can just say this: acts to deceive another person. Okay. Now, the suggestion as a fact of which is not true by one who does not believe it to be true. These are certain things which are a part of this definition of fraud. Okay. You can see here there is colon. It is just a continuation of the definition. Okay. The suggestion as a fact of that which is not true by the one who does not believe it to be true. Okay. You are saying that, take some example. Okay. So if there is a, say, a flat for sale. Okay. Flat for sale. It has, let's say, some problems. Okay. Now this flat is available for a cheaper price. Now the property dealer who is showing you this flat. Okay. He is hiding that truth. He knows something wrong about this flat, but he is hiding it from you. Okay. Whatever it is, even if it is something which is not true, like some people, they say that some flats, they are spooky. Okay. ठीक है, कुछ भूत भूत का ऐसा कहीं कहीं बोलते हैं, right? This is normally not correct. Okay. But if whatever is there, there is some reason for which he has brought down the price, it has to be told to the other party. Then it is up to him to accept or not. So anything अगर कुछ ऐसा छुपा के अगर कुछ किया गया, that is fraud. That is called as fraud. You are concealing something. Okay. So suggestion as a fact of which is not true by one who does not believe it to be true. ठीक है. आपको here the person knows that this is not a very good buy at a low price, and but he's saying it's a very good buy at a low price. Okay. Concealment of a fact. ठीक है, यानी छुपाना कुछ. Then hiding a fact. A promise made without any intention of performing it. Okay. You're saying, no, I'll do it 100%. But you know that you are not going to do it. That is fraud. Right? Then any other act fitted to deceive, any other deceiving act. Okay. Any other act or omission as the law specially declares to be fraudulent. Okay. Any other act or omission as the law specially declares to be fraudulent. Right. So anything which has been declared by the law to be fraud. ठीक है. तो आपको, you don't have to decide whether it's a fraud or not. It's already declared. Okay. So ये है आपका fraud. This is your fraud. Okay. Any act committed to deceive another person. Okay. To induce him to enter into a contract. और इसमें ये सारे टाइप के हो सकते हैं. These are the 5 types which are possible. Okay. All these show that you are deceiving the other party in one way or the other. Okay. Now next is mere silence as to facts is not fraud unless, sometimes what happens is you know that there is something wrong. Okay. So you are not saying that it is right or something, but you are keeping silence. Okay. You are maintaining silence. So mere silence as to facts is not fraud unless, okay, if you are silent, it will not be treated as fraud unless there are some conditions. Unless it is the duty of the person keeping silence to speak. Okay. Where you are silent and the other person is getting some other impression because of your silence. Okay. So in that case, it will be fraud, or unless his silence in itself is equivalent to speech. Silence equivalent to speech मतलब क्या होता है कि जैसे आपने पूछे किसी से कि बोले कि you are just asking, you've seen the house, okay, nobody is saying anything, okay, there is just one old lady, okay, so you think that she will probably give you the right idea. You are just saying, okay, तो सब ठीक तो है ना, you are saying तो सब ठीक है ना माजी, you are asking. Okay, the old lady doesn't say that. Their silence is equivalent to speech because he has asked a question. Okay, if she is not saying no to that question, then okay, that is equivalent to speech. Okay, silence sometimes is equivalent to speech. ठीक है, it's if some नेगेटिव क्वेश्चन मतलब ऐसा कुछ पूछा गया है कि आप कुछ नहीं बोले, अगर आप कुछ नहीं बोलेंगे तो मैं मान लूंगा कि ये सब ठीक है, एंड यू आर रिमेनिंग साइलेंट. ओके, someone is saying if you do not have anything to add, then I will consider this is fine, and you don't say anything in spite of knowing that something is wrong, then that is said to be equivalent to speech. इसको बोलते हैं silence equivalent to speech. Okay, so does silence amount to passive fraud? ये ऊपर जो हमने देखे वही है. Okay, it is the same thing what we have seen here. Okay, the matter on which silence is maintained may be material or immaterial. Okay, if it is immaterial, यानी छोटा मोटा fact, it doesn't affect anything, then it will not be fraud. Okay, if it is a material thing, okay, then it will be fraud as mentioned here. So silence का तभी आप देखेंगे, silence or even undue influence and all, if it is not for a material item, so that will not be considered. Okay, it has to be for a material item. ठीक है, कोई इंपॉर्टेंट चीज के ऊपर होना चाहिए. ठीक है, तो जैसे सपोज मैं बोल रहा हूँ, जैसे आप उसने पूछा अगर कि सुबह in the morning he has to go and get milk. Okay, so where is the milk booth? He's asking where is the milk booth, कहाँ से आप दूध लाते हो. ठीक है, तो आपने बोले ये सामने है. Okay, you are saying it is just ahead, but actually it was not so close. It's not just ahead, but you have to just say it was just a 5 minutes walk. 5 minutes walk था, लेकिन आपने बोला जस्ट सामने है. ठीक है, now that is not a material fact. ओके, तो आप इसको सोच, कल को आप कॉन्ट्रैक्ट कैंसिल करना है, आप ये नहीं बोलेंगे कि जो ये मैंने पूछा मिल्क बूथ कहाँ है, इसने बोला सामने है लेकिन 5 मिनट दूर है. ओके, दैट इज नॉट अ मटेरियल फैक्ट. ओके, ठीक है, so the fact should be material on the basis of which you want to rescind the contract, that should be material. ठीक है, so silence amounts to fraud हमने देखे just now. Okay, fine, silence amounts to fraud okay where there is a change in circumstances and it is not communicated. ठीक है, ये क्या पॉइंट है कि जब आपने कॉन्ट्रैक्ट किए, ओके, व्हेन यू हैव कॉन्ट्रैक्टेड ए एंड बी, ओके, दैट टाइम व्हाटएवर एवरीथिंग वाज फाइन, यू एग्रीड अपॉन इट. उसके बाद वो एग्रीमेंट के टाइम, देन व्हेन कॉन्ट्रैक्ट होने वाला है आपका, एग्रीमेंट एंड कॉन्ट्रैक्ट between them there is some time lag. Okay, after that there is some change. ठीक है, कुछ मटेरियल चेंज हुआ है, circumstances. Okay, there is some material change. ठीक है, so maybe could be a political decision or could be whatever, anything. Okay, and so anything which is a material change that must be communicated. ठीक है, आफ्टर एग्रीमेंट बट बिफोर कॉन्ट्रैक्ट. ठीक है ना, एंड बिफोर कॉन्ट्रैक्ट. सो इफ देयर इज अ चेंज व्हिच इज आफ्टर एग्रीमेंट बट बिफोर द कॉन्ट्रैक्ट, ओके, यू हैव टू टेल इट टू द अदर पर्सन. ओके, ये अगर यहाँ आप चुप रह गए, so then again it will be fraud. When there is a change in circumstances and it is not communicated, so you have to communicate. ठीक है, सेकेंड इज ये एक अलग पॉइंट है. ओके, दिस कॉल्ड एज व्हेन देयर इज हाफ ट्रूथ. ठीक है, व्हेन देयर इज हाफ ट्रूथ. तो हाफ ट्रूथ मींस व्हेन अ पर्सन इज नॉट बाउंड टू, हाफ ट्रूथ का मतलब कैसे, हमने वी हैव सीन साइलेंस. ओके, साइलेंस इज अनदर थिंग. हाफ ट्रूथ मींस व्हेन अ पर्सन इज नॉट बाउंड टू डिस्क्लोज अ फैक्ट, then he may be held guilty of fraud if he volunteers to disclose a state of fact partly. Okay, this is so when the undisclosed part renders the disclosed part false. यानी आपको आपसे किसी ने पूछा नहीं, आपको बोलने की भी जरूरत नहीं है, ठीक है. You don't have to speak anything, but you are unilaterally, you are just going and speaking, oh no, he is a very nice person, like you will not have any problem in dealing with him, he is a very good person. Okay, you are saying something specifically just going to influence his opinion, right? So then that is called as half truth. ठीक है. और एक इसमें क्या चीज होती है हाफ ट्रूथ में, वन मोर थिंग इज वेयर you are actually stating a fact, ठीक है, but you are stating it partly, यानी whatever is good for that person, only that you are stating. For example, इसका easiest example मैं देता हूँ. Okay, that person has 5 business, ठीक है, 1 2 3 4 5, ठीक है, he has 5 business. Okay, now ये 2 में profit है and 4 में profit, others are loss making. So overall his total situation is in a loss, ठीक है. But you are saying, oh no, this his business too, see it is doing so well, and things like that, right? तो ये आप इसको बहुत प्रमोट कर रहे हो, बिजनेस 4 को आप प्रमोट कर रहे हो. ओके, एंड यू आर डिलिबरेटली हाइडिंग 1 3 and 5. ओके, दिस इज कॉल्ड एज हाफ ट्रूथ. ओके, हमारे इसमें एक ये थे एक्चुअली वन real example of like in my life when I was very young. I was a, you can say, in 8th 10th, yeah, somewhere like 7th 8th. Okay, so one of our neighbors, okay, they were well-to-do people, but one of their sons was, he didn't study well. Okay, so he used to drive a auto. Okay, he used to drive an auto because he didn't study well. एक बेटा था उनका. When they married him, okay, when they married him, like this is what we heard. Okay, and what they told is, then because so close to reality, so I'm telling you. Okay, they told like in Hindi कि they said इनके ऑटो चलते हैं. Okay, so there's a very small difference between ये ऑटो चलाता है and इनके ऑटो चलते हैं. Okay, right? So this is a perfect example of half truth. Okay, so okay, fine. Then this is when silence amounts to fraud. Okay, so now we will just go for some examples of these. Okay, so A sells by auction to B a horse which A knows to be unsound. Okay, A says nothing about the horse's unsoundness. So A ने auction में B को horse बेचा, ठीक है, which A knows to be unsound, and he says nothing about the unsoundness. This is not fraud. तो आप बोलेंगे कि if he knows he should have told us, ठीक है, but this is a specific case. In auction sale में क्या होता है, in many auction sale, ठीक है, क्या होता है कि you have to there are many animals for animal auction sale, and okay, there are many kinds of auction sale. You have to come and see whatever is good. If you like it, you have to take it. There's no compulsion on the part of the owner because you are getting at a lower price. So you just have to pick up and you have to take it. Okay. So otherwise, for a normal sale, if he knows it to be unsound and he is selling it for a good price for a sound horse, then he is bound to tell him. ठीक है, normally. लेकिन ऑक्शन सेल में ऐसा नहीं होता है कि यू पिक, आपको जो अच्छा लगे आप लेके जाइए, दैट्स योर रिस्पॉन्सिबिलिटी. ओके, many times the buyer will get many animals, he himself also will not know which animal is what. ठीक है, it's not a one time activity for him. Week after week they will do auction sales, get many animals or whatever, जो भी चीजों का auction हो रहा है. Okay, so which is why as per auction there is no responsibility to tell someone that something is unsound. But if you are a regular dealer, okay, and you are known to sell good quality horses, and you are selling a horse for a good price, which is unsound, that you have to tell. Okay, fine. Then B is A's daughter and has just come of age. Okay, okay, that she has become an adult. Okay, B is A's daughter and just come of age. So इसी का continuation. Okay, this is continuation of this. Now here, if A is selling the horse to B, his daughter, okay, then he has his duty is to tell B that the horse is unsound. Okay, because B is now inexperienced and it is A's responsibility to guide him. So he should tell her that horse is unsound. Okay, and then B says to A. Okay, now this is the negative sentence. Okay, if you do not deny it, I shall assume that the horse is sound. A stays silent. Because here he said, if you do not deny it, I shall assume horse is sound. And he doesn't deny it, right? He's silent. So that means he is saying that the horse is sound. ऐसा माना जाएगा. The silence is equivalent to speech. Okay? Here silent is equivalent to speech. Fine? Now, A and B enter upon a contract. Okay, A has private information of change in prices which would affect B's willingness to proceed with the contract. A is not bound to inform. Okay. Agar if you are say, now there are two people A and B. Okay. You are dealing in, ठीक है, कोई भी आप स्टॉक नॉर्मल कोर्स में यू आर डीलिंग इन अ स्टॉक शेयर मान लीजिए, ठीक है, यू आर सेलिंग हिम 100 shares at whatever price and he is ready to buy. Okay, right? So now this contract will be done tomorrow. Everything is fine, it will be done tomorrow. Okay, now suppose let us say A's wife, she works in the stock exchange, she got some internal information, okay, which is not open information, public information. Okay, so she got some internal information that the price of these shares is going to fall tomorrow or day after tomorrow, let us say, after the contract, the price will fall. Now A is not bound to tell B because this information he has not got from his official sources. It's just chance that his wife worked there, so he came to know. Okay, if any other trader was there in A's place, any other trader was there, B would have bought it and later on the price would have fallen. Okay, so here it is not a fraud. Okay, remember that. ठीक है, यहाँ पे किसी का अगर प्राइवेट इंफॉर्मेशन है तो प्राइवेट इंफॉर्मेशन के ऊपर से आपने एक्ट करना चाहिए, ऐसा लॉ नहीं बोलता. ओके, इट शुड बी पब्लिक इंफॉर्मेशन नोन टू एवरीवन. ठीक है, तो चलिए देन effect of fraud and then I'll give you a break. Effect of fraud. If a consent is caused by coercion, fraud, misrepresentation, okay, contract is voidable at the option of other party. Whoever is the agreed party, उसके ऊपर है, वो चाहे तो कॉन्ट्रैक्ट कैंसिल कर दे, चाहे तो इफ ही स्टिल फील्स नो दिस इज गुड फॉर मी in spite of the coercion, fraud or misrepresentation, the contract is still good for me. Sometimes it happens, right? In the end, the contract is good for you, right? So in that case, okay, so you can continue with the contract also. It is up to the aggrieved party. Okay, contract is voidable at the option of other party. Effect of fraud, coercion, misrepresentation is contract is voidable at the option of other party. Okay, तीनों का same for all three. Such other party can insist that the contract shall be performed. Fine. So now, okay, I'll just finish this much. Okay, then next is misrepresentation, right? Next जो है हमारा is misrepresentation. So I'll just finish this much. Okay, and then we'll go for a break. One exception to the rule of voidability of contract. Okay, so this is one exception. The contract will not be voidable as mentioned here. Voidable. Okay, if the consent was caused by misrepresentation or by silence which is fraudulent. Okay, ठीक है, वो सेक्शन वगैरह के ऊपर ध्यान देने की जरूरत नहीं है. Okay, if the consent was caused by misrepresentation or by silence, ठीक है. Okay, तो the contract is not voidable. Okay, जो भी है इसमें से जो भी है, okay, the contract is not voidable if the other party had the means of discovering the truth with ordinary diligence. ठीक है, so if you could find the truth out very easily, then you cannot blame the other party. Okay? Just because, I mean, he said that no, it is very good, it was not good, but you came to know that it was not good. Okay? It was very easily you found out. Now you cannot use it as a pretext to say that contract will be void because you knew and then you entered the contract. Correct? Okay? So ये problem बात है. If it is misrepresentation or silence which is fraudulent, okay, contract can be voidable if the other person has means of discovering it. Okay, coercion क्यों नहीं बोला? Coercion में तो मारपीट करके उसने मनवाया, right? So that can never be okay. Okay, this is basically for anything other than use of force. Okay, understood? Next will be our misrepresentation, and यहाँ पे हम will go for a break, and you will come back at 7:30. ठीक है, come back at 7:30. Right. Okay, so welcome back. We'll continue. The next is misrepresentation. Okay, these are the things which cause consent not to be free. Okay, so fourth one is misrepresentation. Okay, what is misrepresentation? Statement of fact which one party makes, okay, in the course of negotiation to induce the other party to enter into a contract. This is called as misrepresentation. Okay. So misrepresentation means it is just a statement of fact which one party makes, okay, in a course of negotiation. Now here he doesn't know that that is wrong. Okay, but eventually it turns out to be wrong. ठीक है, यानी मिसरिप्रेजेंटेशन और फ्रॉड में फर्क ये है. एक्चुअली आप अगर किस डायग्राम भी इसका देखेंगे तो मिसरिप्रेजेंटेशन के अंदर मिसरिप्रेजेंटेशन इज द मेन हेड और इसमें आता है विलफुल और नॉन विलफुल. विलफुल इज फ्रॉड, नॉट विलफुल इज मिसरिप्रेजेंटेशन. ठीक है, इस तरह से देखा जाता है. सो दिस इज बेसिकली something you have said something which is incorrect, okay, and that has caused loss to the other party. Okay, so basically your contract is induced by something which you have said and it is wrong, but you believed it to be right. आपने सोचा कि वो करेक्ट. ठीक है, तो फ्रॉडुलेंट माइंड से नहीं किया गया है. ठीक है, that is your misrepresentation, and that fact must be a material fact that we have always seen. ठीक है, it should be material fact, right? Otherwise contract will not become void. It may be expressed by words, spoken or written, or implied from the acts of parties. ठीक है, it can be expressed or implied. ठीक है, misrepresentation का जो fact है that can be either expressed or implied. So main चीज क्या है misrepresentation में? Okay, what is the main thing? That you have said something or you have represented something during the contract negotiations, that thing turned out to be wrong. Okay, but you had believed it to be right. Okay, so there is no fraudulent intention, but because you have said something wrong, contract will be impacted by it. Okay, a representation when wrongly made, either innocently or unintentionally, ठीक है, इसको बोलते हैं मिसरिप्रेजेंटेशन. आप ये देखिए, इट इज रॉन्गली मेड. ठीक है, व्हाट यू सेड वाज रॉन्ग बट इट वाज आइदर इनोसेंट. ठीक है, तो आपने सही समझ के बोले और अनइंटेंशनली. सो बेसिकली यू थॉट दैट इट इज राइट. ओके, सो देन इट इज मिसरिप्रेजेंटेशन. बट सेम थिंग व्हेन इंटेंशनली और विलफुली हो जाता है, इट बिकम्स अ फ्रॉड. ओके, दैट्स द connection between misrepresentation and fraud. Fine. Now let us see definition of misrepresentation. Okay, so first one is the positive assertion in a manner not warranted by the information of the person making it, ठीक है, of that which is not true though he believes it to be true. So this is important. Okay, he believes it to be true all along. ठीक है, तो वो कुछ झूठ नहीं बोल रहा है उसके हिसाब से. He is not lying or stating anything which is false. He believes it to be true. ठीक है, so three ways of misrepresentation can be. One is a positive assertion. You are saying no, 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 do this. This will give you good result. Okay, you believe it, but then that turned out to be wrong. Okay, so positive assertion is the first one, and then second kind of misrepresentation is a breach of duty without an intent to deceive. So in misrepresentation, there will always be without intent to deceive. Okay, breach of duty which without intent to deceive gains an advantage to the person committing it by misleading another. ठीक है, breach of duty कर रहे हैं. breach of duty कब हो जाएगा? See, when you are getting the information from an official person. ठीक है, so say someone, many times when we are in when we go to a bank or post office, or okay, so we try to get some information from them, which is good. Okay, which you think will be more beneficial. So if that person says, okay, this one will be more beneficial, okay, and say it turned out to be false, but because he was in his duty, course of duty, so it becomes breach of duty. Okay, yeah, almost similar to the first one. It is similar, okay. Causing, however innocently, okay, causing, however innocently, a party to an agreement to make a mistake as to the substance of the thing, which is the subject of the agreement. Subject matter, आपने इस तरह से उसको बताए हैं कि he has got the subject matter wrong. Okay, something, यानी he has not got the subject matter wrong, he has made a mistake in something which is very material. ठीक है, right? But you did it innocently. So these are the kinds of misrepresentation. Fine. ठीक है, two types of misrepresentation. So based on this only, ये जो हमने ये 3 points देखे ना, you can summarize it into 2 points. One is unwarranted statements. So the first point, when the person positively asserts, okay, no, this will happen, although he did not have any reliable source, but he believes it to be true. This is the first one. Okay. Second is breach of duty. Okay. Breach of duty through which you have misled the other person, but you thought that you are saying the right thing. Okay. So when you are doing in the course of your duty, it becomes breach of duty. Okay. These are the two main parts of misrepresentation. What will be the effect of misrepresentation? Next. Okay, contract is voidable at the option of the party whose consent was so caused. This is also same. Contract becomes voidable. He may insist that contract shall be performed. Exception is same if it was caused by misrepresentation or by silence. Consent was caused by misrepresentation or by silence, okay, which is fraudulent. Okay, the contract is not voidable, okay, if the other party could discover it with due or with ordinary diligence. Okay, so this would be, if the other party could discover it with ordinary diligence, then it will not be voidable. Okay, now an explanation to this is fraud or misrepresentation which did not cause the consent to the contract of a party doesn't make it voidable. Okay, so there is a fraud or misrepresentation, but the other person did not give his consent based on that, then the contract is not voidable. Okay, so for example, A and B are negotiating a contract. Okay, let's say B has done some fraud or misrepresentation. Okay, while explaining the contract to A, but A actually has a much better source to understand the contract. Source C, say his friend or whatever, that he told him everything properly about this contract. So A did not rely on B. So because A did not rely on B, now the contract will not be voidable if A accepts it. Okay. Okay. Now these are some examples. A intending to deceive B falsely represents that 500 mounds of indigo are made, and A wanted to deceive B. Okay. So falsely represents that 500 mounds of indigo are made annually at A's factory, at his factory. Okay, ये यहाँ A अपनी फैक्ट्री बेच रहा है B को, और A बोल रहा है कि 500 mounds of indigo बनता है annually. Okay, so and thereby induces B to buy the factory. So contract is voidable at the option of B. Okay, so if A is intending to deceive B, and he falsely says that 500 wants, he has just increased the production value, which is showing to B. Okay. In that case, it becomes voidable. Same thing as above. Okay. Same example as above. Here, what we are saying is A again, by misrepresentation, led B to believe that 500 mounts of indigo are made annually at A's factory. Okay. But B examines the records and he knows that only 400 mounts are made annually. Then he buys the factory. Now the contract is not voidable. Okay, because he knew. If he knows, it is not voidable. Okay. Now next is A fraudulently informs B that A's estate is free from encumbrance. यानी there is no charge on his estate. ठीक है, so गिरवी रख के कोई पैसे नहीं लिया है, वो मतलब. So A fraudulently informs B that A's estate is free from encumbrance. Now B thereupon buys the estate. Okay, B buys the estate. Now it turned out that estate is subject to mortgage. So B may either avoid the contract or may insist on its being carried out and mortgage debt redeemed by A. ठीक है, समझ में आ गया होगा? Fine. So in this case, B can either avoid the contract, it becomes voidable, so he can avoid it, or he can say that you carry out the contract and clear the mortgage. Okay. Then you have B having discovered a vein of ore. Okay. On the estate of A. So in estate of A, B discovered some ore and a mineral दिखा उसको कुछ. Okay. So but A did not tell B did not tell A that in your estate there is this ore. Okay. And he bought it from A. ठीक है, वो पूरा estate को उसने खरीद लिया at less value. Had A known that there is an ore, say the value would have been double. Right? So now it is voidable at the option of A. ठीक है, तो यहाँ पे A के estate में कुछ mineral मिला B को, mineral ore है करके deposits. So वो बताए बिना B ने A से estate खरीद लिया कम price. Whenever A comes to know, वो contract को void कर सकते. Okay. Now next is A is entitled to succeed to an estate at the death of B. Okay. So that means B has an estate. After his death, A would have got the estate. Okay. So B dies. Okay. So C having received intelligence about B's death. Okay. So C came to know that B has died, but he didn't tell A. And he just bought the interest of A's interest. Okay. At the current situation, A interest has got the entire estate because of death of B. It just doesn't have an interest. ठीक है, उसको पूरा estate मिल गया है, लेकिन C didn't tell A that B has died. Okay, and bought his interest at a lower price. Okay, so in that case it is voidable. Okay. So now next we are going to talk about is mistake. Okay. Next is mistake. Okay. Last one. This is the last one, which is mistake. Okay. These are the 5 things which make a consent to be not free. Okay. This is the 5th one. So what is mistake? It's an erroneous belief about something. Okay. It is not defined in the Indian Contract Act. Okay. The mistake ko overall we take it from हमारे फॉरेन एक्ट से हम इसको परस्यू करते हैं बेस्ड ऑन सम केसेस. ओके, so the Contract Act has not defined it specifically. Okay, so now ठीक है, so ऑल्दो हमको जो है इसके we will get certain things about mistake in contract act, but it is not defined the term as such. ठीक है, बाकी सारे इसमें we have seen that terms have been defined. Okay, so now, so mistake means what? It's an erroneous belief about something. Okay, that what you are believing is not true. Okay, erroneous belief about anything. Mistakes can be, okay, mistake of law, section 21, or mistake of fact. Okay, which is section 20. So mistake can be divided into mistake of law and mistake of fact. Okay, so two types के mistakes. Mistake of law can further be subdivided. Okay, ये first वाला ले रहे हैं, this one, mistake of law. Okay, so mistake of law can be mistake of law of our country, mistake of law of foreign country. ठीक है, mistake of law of foreign country. Then अब इसमें लेंगे मिस्टेक ऑफ लॉ ऑफ आवर कंट्री. ठीक है, मिस्टेक ऑफ लॉ ऑफ आवर कंट्री. ओके, सो ना कॉन्ट्रैक्ट विदाउट नॉलेज of the law of the country is affected by the mistake but is not void. ठीक है, तो अगर आप बोलोगे कि जैसे अरे हमको पता ही नहीं था, बोलेंगे सब सारी गलती करके एंड में यू से कि आई डिडंट नो एट ऑल. ठीक है, तो ऐसा नहीं चलता, राइट? So which is why, and it's your country, so you have to know the law, correct? So which is why अगर आपको नहीं मालूम है तो आपको पता करके ही आगे जाना पड़ेगा. if we want to do something new, what do? We find out all laws about that, rules पता करते हैं, right? So then what will happen? Anyone will do anything, they will then say मुझे पता ही नहीं था, right? So this cannot be allowed. So it is, contract doesn't become void if there is mistake of law of country. Okay, contract is not voidable because it was caused by mistake as to any law in force in India. Okay, reason is ignorance of law is not an excuse. Okay, so if induced to enter into a contract by mistake of law, contract can be avoided. यानी अगर किसी ने, if someone has induced you, that somebody has told you, no, he's told you a wrong law, so that you will enter the contract, then it will become voidable. Okay, if someone has induced it. Okay, so this is about mistake of law. Second was mistake of fact. ठीक है, वो तो हो गया mistake of law. Mistake of fact, it can be bilateral mistake or unilateral mistake. Okay, so we'll see bilateral mistake first, when both the parties are under a mistake. ठीक है, so ठीक है, so here we'll talk about bilateral mistake. Okay, bilateral mistake में when both the parties are under mistake of essential fact, agreement is void. ठीक है, so essential fact is fact essential to the contract. ठीक है, दोनों से मिस्टेक हुआ है. ओके, एंड इट्स नॉट अ मिस्टेक ऑफ लॉ, बट दोनों से मिस्टेक हो गया है. ठीक है, so one person thought that he is talking about one city, कोई और सिटी. दूसरा सोच रहा है कि ये कोई और सिटी की बात कर रहा है. Say two cities which are very close in spellings or pronunciation. Okay, ऐसा कुछ मिस्टेक हो गया. So both parties were under the mistake of the same thing. एक ही चीज के लिए ये कुछ और सोच रहा है, ये कुछ और सोच रहा है. Okay, both are thinking differently. That is called as bilateral mistake. Okay, now here's one thing is there, erroneous opinion as to value of a thing, it is not mistake. यानी इसका क्या मतलब है? वैल्यू की बात कर रहा है. ठीक है, ऐसा ये प्राइस की बात नहीं कर रहा है. वैल्यू मीन्स आपने सोच, you thought that what you are buying is of very high value in market, but later it turned out that its value is less. ठीक है, आपका अगर if there is an erroneous opinion as to value, that is not mistake, it is considered as unilateral. एक ही साइड का माना जाता है वो. ठीक है, so जैसे आपने मान लीजिए यू वेंट टू बाय सम फ्रूट्स, you bought some fruits for 500 thinking it is very costly, then by the time you came home you saw that oh it's only for 200. Okay, so now this is not voidable for you. Okay, so ये है, and then see now next thing is for agreement to become void due to bilateral mistake two conditions are essential. दो conditions meet होने चाहिए. Okay, one is mistake must be mutual, both मैं कुछ समझ रहा हूँ वो कुछ समझ रहा है. Okay, mistake must be mutual, both parties must misunderstand each other and should be at cross purpose. ठीक है, तो मैं जिस चीज के बारे में जो समझ रहा हूँ वो उसी चीज के बारे में कुछ और समझ रहा है. ओके, should be at cross purpose. Mistake must relate to a matter of fact essential to the agreement. ठीक है, तो मतलब मिस्टेक वही बात हो गई ना कि इट शुड बी समथिंग एसेंशियल टू द एग्रीमेंट, इट शुड बी समथिंग इंपॉर्टेंट. एज आई सेड कि कहाँ पे मिल्क बूथ कहाँ है बोले तो इफ ही इज सेइंग तो सामने में है हिज सेइंग, बट इट वाज एक्चुअली 5 minutes वॉक. ठीक है, दैट्स एन इमेटीरियल फैक्ट, right? It's not an essential fact. Mistake must relate to matter of fact essential to the agreement. ठीक है, it depends on the nature of promise in each case. ठीक है, of course यानी promise के हिसाब से पता चलेगा कि what is essential what is not. Okay, किसी contract में there is something which will be essential, same thing will be immaterial for some other contract. Okay, it's possible. ठीक है, तो ये हो गया हमारा यूनिलैटरल मिस्टेक, sorry, bilateral mistake. Now unilateral, now first we will see types of bilateral mistakes, यानी कैसे कैसे हो सकते हैं हमारे. ठीक है, types of bilateral mistakes. Okay, one is mistake as to subject matter. ठीक है, first one is mistake as to subject matter covers the following cases, of course renders the agreement void. ठीक है, ये अगर आपने सब्जेक्ट मैटर ही गलत समझा दोनों ने, ठीक है, so it is void. ठीक है, तो जैसे अभी दो दो पार्टीज है, दोनों ने तेल ऑयल का कॉन्ट्रैक्ट किया. ओके, ऑयल लेने का, बट वन दिस पर्सन वाज थिंकिंग, he was thinking about groundnut oil or he was thinking about whatever you say, uh, मान लीजिए तिल ऑयल. ओके, ठीक है ना, तो ये इसको बोलते हैं बायलैटरल मिस्टेक. तो मेन सब्जेक्ट मैटर में दोनों में गलती होगी. ठीक है, सो मिस्टेक एज टू सब्जेक्ट मैटर कवर्स द फॉलोइंग केसेस. ये क्या होता है ना, 5 चीजें हैं इसमें, आपको याद रखना वर्ड्स जो है. वन इज एग्जिस्टेंस. ओके, एग्जिस्टेंस ऑफ सब्जेक्ट मैटर. ठीक है, जो सब्जेक्ट मैटर के बारे में ये सोचा वो सब्जेक्ट मैटर उसने सोचा है ही नहीं. ओके, एग्जिस्टेंस में ही डाउट हो गया, डाउट इन द एग्जिस्टेंस ऑफ सब्जेक्ट मैटर. मिस्टेक एज टू आइडेंटिटी ऑफ सब्जेक्ट मैटर. ओके, मिस्टेक एज टू आइडेंटिटी ऑफ सब्जेक्ट मैटर, यानी सब्जेक्ट मैटर तो है बट आइडेंटिटी, यानी वही मैंने बोला जैसे someone is thinking groundnut oil, someone else is thinking तिल oil. ओके, दिस इज आइडेंटिटी. एग्जिस्टेंस यानी सब्जेक्ट मैटर ही है कि नहीं उसी में, ये हो गया. ठीक है, what one is thinking to be subject matter is not the subject matter for another. So existence, identity, और ये आइडेंटिटी में if both parties have different subject matter in mind. ठीक है ना, then mistake as to quality of subject matter. ठीक है, कई बार quality is also very important, as you know different qualities of things have very different prices. ठीक है, for example you have gone for a, क्या बोलते हैं इसको, प्लाईवुड. ठीक है, इन प्लाईवुड देयर आर वेरियस थिकनेसेस. ठीक है, एंड द प्राइसेस आर वेरी डिफरेंट. You want a thin one or you want a very thick one, prices will be very different. Correct, there can be different mistake as to quality. ठीक है, देन इसके बाद नेक्स्ट है क्वांटिटी. ओके, क्वांटिटी का भी हो सकता है. देन टाइटल ऑफ सब्जेक्ट मैटर. ओके, टाइटल में यानी आप अपने लिए ले रहे हैं टाइटल, बट ही इज थिंकिंग मे बी दैट टाइटल विल रिमेन विथ हिम एंड यू विल टेक इट ऑन लीज, ऐसा कुछ. ठीक है, टाइटल में कुछ प्रॉब्लम हुआ है, राइट. एंड देन प्राइस, लास्ट इज प्राइस. ठीक है, तो इतने तरह के सब्जेक्ट मैटर रिलेटेड मिस्टेक्स हो सकते हैं. दिस मिस्टेक एज टू सब्जेक्ट मैटर. ठीक है, बायलैटरल मिस्टेक. नंबर 2, so ये था नंबर 1, करेक्ट. दिस वाज नंबर 1. अब हम देखेंगे नंबर 2. दिस इज नंबर 2. ठीक है, मिस्टेक एज टू पॉसिबिलिटी ऑफ परफॉर्मेंस ऑफ कॉन्ट्रैक्ट. ठीक है, पॉसिबिलिटी ऑफ परफॉर्मेंस है ना, कॉन्ट्रैक्ट हो सकता है कि नहीं. इफ इट इज इम्पॉसिबल देन इट विल बिकम void. So impossibility may be physical impossibility. Physical impossibility तब होता है कि where a contact cannot happen due to physical factors. ठीक है, like time, distance, height. Okay, जैसे इसका एक एग्जांपल है कि you have taken a contract for digging a well. ठीक है, आपने कॉन्ट्रैक्ट लिए हो फॉर डिगिंग अ वेल. ठीक है, वेल मान लीजिए यू आर सेइंग ओके 50 feet डीप. ठीक है, then it came to light that that particular soil is such that you cannot dig beyond 20 feet. ठीक है, नहीं 20 feet के ज्यादा आप डिग नहीं कर सकते. ओके, तो ये तो वही इम्पॉसिबिलिटी हो गया, फिजिकल इम्पॉसिबिलिटी हो गया, करेक्ट. फिजिकली इट इज नॉट पॉसिबल. दैट इज फिजिकल इम्पॉसिबिलिटी. लीगल इम्पॉसिबिलिटी इज the law doesn't allow you to do it, but both of you didn't know it. ऐसा कुछ जो लॉ आपको अलाउ नहीं करता, दैट इज लीगल इम्पॉसिबिलिटी. 2 टाइप्स ऑफ इम्पॉसिबिलिटीज आर देयर. ठीक है, वन एग्जांपल हियर इज A agrees to sell B a specific cargo of goods supposed to be on its way from England to Bombay. ठीक है, so A wants to sell to B a cargo of goods. ठीक है, consignment of goods coming from England to Bombay. ठीक है, before the day of the bargain the ship sank. ठीक है, cast away मतलब वो it kind of sank, you can say. ठीक है, and the goods were lost, but they did not know that. ठीक है, so agreement becomes void. Okay, because both were at a mistake. Mistake क्या था, दोनों को लग रहा था the goods are available to be sold. Both parties thought that. Now it is not available to be sold. Okay, so ये mistake में फायदा ये है, otherwise buyer can buyer can impose penalty on the seller. But here what happens, because of mistake contract gets cancelled. Penalty that cannot be imposed. Okay, if it is a mutual mistake. A being entitled to an estate for the life of B. ठीक है, life of B का मतलब है कि जब तक till B is alive, A will have the estate. A is the owner of the asset, but after B dies, he doesn't have any right on the estate. ऐसे कुछ conditions भी होते हैं. ठीक है, so A being entitled to an estate for the life of B agrees to sell it to C. ठीक है, so he can deal it the way he wants to till B is alive. ठीक है, but B was dead at the time of agreement. So no, both of them did not know it, so agreement became void. ठीक है, इसमें advantage वही है कि penalty clause doesn't apply. Okay, that's the advantage of mistake. अब next लीजिए unilateral mistake. Bilateral mistake we saw. Next is unilateral mistake. Contract is not voidable due to one party being under a mistake of fact. Contract हो गया, contract has been done, but you thought something else. ठीक है, तो उसके कारण contract cannot be void. Okay, when everything has been written, ठीक है, contract you have signed, I have signed, contract is as per what is written, but then you said I thought it is like that. So then nobody can help you, right? So unilateral mistake में contract doesn't become void and it is a good contract. ठीक है, unilateral mistake is not allowed as a defense in avoiding contract unless brought about by another party's fraud or misrepresentation. If fraudulently someone has induced that mistake, तो अलग चीज है, ठीक है, otherwise नहीं होगा. Okay, so now before I go to quasi contract, which is next topic, ठीक है, I'll just take you, ठीक है, तो मैं आपको ये टेबल दिखाता हूँ एक बार मिस्टेक का. ओके, दिस इज व्हाट वी हैव स्टडीड. ओके, सो स्टार्टिंग विथ फ्लॉ इन कंसेंट. ठीक है, कंसेंट फ्री नहीं है, देयर इज सम फ्लॉ, ठीक है, इन कंसेंट. वन इज कोअर्शन, अनड्यू इन्फ्लुएंस, ठीक है. मिसरिप्रेजेंटेशन में टू पार्ट्स है, वन इज फ्रॉड एंड वन इज इनोसेंट, विच इसको हम मिसरिप्रेजेंटेशन बोलते हैं. दिस इज कॉल्ड एज, दिस वी नॉर्मली कॉल एज मिसरिप्रेजेंटेशन, ठीक है, राइट. सो मिसरिप्रेजेंटेशन, और ये हो गया लास्ट इज मिस्टेक. ठीक है, ये 5 चीज पढ़े थे हमने: कोअर्शन, अनड्यू इन्फ्लुएंस, फ्रॉड, मिसरिप्रेजेंटेशन, मिस्टेक. ठीक है, इट्स एक्चुअली लाइक दिस कि मिसरिप्रेजेंटेशन इज द मेन हेड, फ्रॉडुलेंट है तो आप फ्रॉड लिखेंगे, अदरवाइज अनइंटेंशनल मिसरिप्रेजेंटेशन रहेगा. ठीक है, तो इसको बोलते हैं मिसरिप्रेजेंटेशन नॉर्मली. ओके, एंड दिस इज कॉल्ड एज फ्रॉड. अच्छा, नाउ दिस मच वी हैव सीन. इसके बाद आपका मिस्टेक. ठीक है, और इस मिस्टेक में देयर आर टू पार्ट्स: मिस्टेक ऑफ लॉ, मिस्टेक ऑफ फैक्ट. ओके, अब मिस्टेक ऑफ लॉ में हमने देखा आइदर मिस्टेक ऑफ लॉ ऑफ ओन कंट्री और अनदर कंट्री. ठीक है, तो मिस्टेक ऑफ लॉ ऑफ ओन कंट्री है तो देयर इज नो रेमेडी. ठीक है, यू मस्ट नो द लॉ ऑफ योर कंट्री. But mistake of law of foreign country is treated as mistake of fact. The second one इस लाइन में चले जाएगा. ओके, so mistake of fact can be bilateral or unilateral. ठीक है, so for bilateral mistake, ये आपका bilateral. ठीक है, bilateral में, so if it is a unilateral mistake, again there is no remedy, वो वहाँ खत्म हो जाता है. ओके, तो bilateral mistake ये यहाँ जाएगा. ठीक है, टू पार्ट्स: मिस्टेक एज टू सब्जेक्ट मैटर, ठीक है, मिस्टेक एज टू पॉसिबिलिटी ऑफ परफॉर्मेंस. सब्जेक्ट मैटर में हमने ये सब देखे: एग्जिस्टेंस, ठीक है, आइडेंटिटी, क्वालिटी, क्वांटिटी, टाइटल, प्राइस. ठीक है, 6 थिंग्स वी हैड सीन. और इम्पॉसिबिलिटी में फिजिकल एंड लीगल इम्पॉसिबिलिटी. ओके, these two are physical and legal impossibility. Okay, this is the chart of consent or flaw in consent. ठीक है, okay. Now next we are talking about quasi contracts, contingent contracts, termination or discharge of contracts. ठीक है, next we are going to talk about quasi contracts, contingent contracts, टर्मिनेशन और डिस्चार्ज ऑफ कॉन्ट्रैक्ट्स. ठीक है, तो एक एक करके हम लेंगे. फर्स्ट इज क्वाजी कॉन्ट्रैक्ट्स. ठीक है, और उसका एक्चुअल प्रोनाउंसिएशन इज क्वेजाई, क्वेजाई कॉन्ट्रैक्ट्स. ओके, चलिए देन उसके बाद लेंगे कंटिंजेंट कॉन्ट्रैक्ट्स. ठीक है, देन टर्मिनेशन एंड डिस्चार्ज ऑफ कॉन्ट्रैक्ट्स. नाउ चलो, क्वेजाई कॉन्ट्रैक्ट्स. ठीक है, इट इज, ये क्या होता है? ठीक है, क्वेजाई कॉन्ट्रैक्ट. तो जो क्वेजाई वर्ड है आपने पहले भी सुने होंगे कई बार जरूर. ठीक है, तो क्वेजाई इज समथिंग जो फुल्ली प्योर नहीं है, जैसे जो जिसको हम बोलते हैं जैसे एनीथिंग क्वेजाई, मतलब एक डुप्लीकेट काइंड ऑफ. ठीक है, डुप्लीकेट काइंड ऑफ चीज है. ठीक है, जो रियल नहीं है फुल्ली, उसके जैसा है, उसके जैसा, किसी के जैसा है तो उसको क्वेजाई बोलते हैं. ओके, so now, so quasi contract means there is no contract but it law treats it like a contract. There is no contract, but law treats it like a contract. Sometimes the law implies a promise imposing obligations on one party and conferring the right in favor of the other, even when there is no offer, no acceptance, no consensus added up. Okay. So sometimes law implies a promise. Okay. Imply कर रहा है ना, law is implying that there is a contract, although there is no direct contract between the parties. ठीक है, कुछ भी नहीं, agreement, promise, nothing is there, right? So such cases are not contracts, but the court recognizes them as relations resembling contracts and enforces them as if they were contracts. It's called as quasi-contract. Okay. It rests on the equitable principle that a person will not be allowed to enrich himself unjustly. ठीक है, on behalf at the expense of another. ठीक है, यानी किसी का यानी ये इसीलिए बनाया गया है कि nobody should enrich himself unjustly, यानी किसी का belonging था उसको आपने रख लिए. ओके, ऐसा ऐसी कुछ चीजें नहीं होना चाहिए, इसीलिए ये रूल बनाया गया है. ओके, so nobody should be allowed to enrich himself unjustly at the expense of other. ये important point है जो लिखना है. You have to write this. A person shall not be allowed to enrich himself unjustly at the expense of other. ठीक है, this is why quasi contracts are formed. Okay, so if a person is in possession of another person's money or its equivalent, he should not retain it. Okay, as in justice and fairness, it belongs to another. ठीक है, किसी और के पैसे या कुछ हमको मिल गए, right? If we have got any other person's belongings, we must return it to him. Okay, so इसीलिए quasi contract का condition डाला गया है, so that नहीं तो क्या होगा, किसी को भी किसी का belonging मिल जाएगा, वो रख ले. Okay, so now it is a duty and not an agreement or an intention which defines it. It is defined by duty. Okay, not an agreement or intention. Okay, अब देखते हैं types of quasi contracts. ठीक है, सबसे पहला है claims for necessaries supplied to person incapable of contract on his account. ठीक है, so if a person is incapable of contracting, right, कोई है minor है, person of unsound mind है, okay, or person who cannot contract है, ठीक है, and you are supplying necessaries for his life. ठीक है ना, आप उसको कुछ राशन or something like that you are giving. Okay, so then क्या होता है कि then he should you are entitled to be reimbursed from the property of such incapable person. ठीक है, आप जो दे रहे हो, whatever you are giving him, whatever ration or whatever regular things you are giving him for his life, okay, if he has money, if he has estate, then he should pay for it. ठीक है, so you are entitled to be reimbursed from the property of such incapable person. ठीक है, right? वो या तो आप दे रहे हो for to the incapable person or to his family. ठीक है, you can give it to his family also. ठीक है, so he also, incapable people will also have family and they have to be maintained, correct? Reimbursement of persons paying money due by another in payment of which he is interested. ठीक है, now ये this is another point. Reimbursement of money paying money, reimbursement of persons paying money due by another in payment of which he is interested. ठीक है, ये वाला पॉइंट मैं समझाऊंगा एक एग्जांपल के साथ, so it will be easier. So this one you have understood, I think. Claim of necessaries supplied to person incapable of contracting. ठीक है, so the person who is supplying, he is entitled to be reimbursed from the person's estate or property. ठीक है, incapable person का जो estate या property है, from that he is capable of being reimbursed. दूसरा है reimbursement of persons paying money due by another in payment of which he is interested. ये क्या है मैं आपको बताता हूँ. ठीक है, तो इसका एग्जांपल है ये रीइंबर्समेंट वाले पॉइंट का, ठीक है। दिस इज, तो बी होल्ड्स लैंड इन बंगाल ऑन अ लीज ग्रांटेड बाय ए द जमींदार, ठीक है। जमींदार है, ठीक है, और बी टेनेंट है, बी इज टेनेंट नाउ, ठीक है। अब जमींदार ने जो है टैक्स नहीं भरा बहुत दिन से, लैंड रेवेन्यू नहीं भरा, ओके। लैंड रेवेन्यू इज इन अरियर, ठीक है। एंड गवर्नमेंट has advertised this land for sale. So what does government do? If you have not paid taxes for many years, okay, it will uh, put your land, your property for sale, ठीक है, and get its arrears of revenue, ठीक है। So government has put it on sale. अब now it is sold, then ये जो B tenant है, he has already made lots of investment वहां पे, ठीक है। So उसका नुकसान हो जाएगा ना, तो इसने क्या किया, what he did is he paid the revenue on behalf of the जमींदार to the government. Understood? समझ में आ गया ना। यहाँ पे क्या हो गया कि there was one जमींदार, A is जमींदार, जमींदार था, and Iyer is a tenant, ठीक है। जमींदार did not pay land revenue for a long time. Government put the land for sale. So now the tenant B, he paid the arrears of land revenue to the government, ठीक है। नाउ बी इज एंटाइटल्ड टू रिकवर इट फ्रॉम द जमींदार, ठीक है। वही ये सेंटेंस है, reimbursement of persons paying money due by another, and a tenant is paying money due by zamindar, in payment of which he मतलब tenant is interested, tenant is interested, right? नहीं तो उसका जमीन जब्त हो जाएगा, whatever he has invested वो भी चले जाएगा, right? So it is like that, ठीक है। So तो इसीलिए यहाँ पे जो है बस इसमें बी हैज पेड और ए इज नाउ बाउंड टू रीपे, बस उतना ही है और कुछ, ठीक है। नाउ ऑब्लिगेशन ऑफ अ पर्सन एंजॉइंग बेनिफिट ऑफ नॉन ग्रेचुइटस एक्ट, ठीक है। इसमें क्या है, पर्सन लॉफुली डज एनीथिंग फॉर अनदर पर्सन और डिलीवर्स हिम एनीथिंग टू हिम, नॉट इंटेंडिंग टू डू सो ग्रेचुitously, okay, such person and the other person enjoys benefit, then he is bound to compensate the former, ठीक है। इसको बोलते हैं क्वांटम मेरिट, ठीक है। ये वाले इस कंडीशन को बोलते हैं क्वांटम मेरिट, यानी सपोज मान लीजिए ना, बेस्ट चीज है कि नाउ वी मेनी टाइम्स ऑर्डर थिंग्स ऑनलाइन, ठीक है, ऑनलाइन। तो ऑनलाइन वाले आया और आपके डोर के जगह में भी बाय मिस्टेक ही हैज गिवन इट टू समवन एल्स, so does it mean the other person should start using it? No, right? If he starts using it, then he will have to compensate you, isn't it? है ना। तो वही वही बात है बोल रहे हैं कि he has got it, but it is a non gratuitous act, तो आपने उसको फ्री में खाने के लिए आपने नहीं दिया है, राइट। तो बेसिकली यू बॉट इट फॉर योरसेल्फ, बट ही गॉट इट। पिज्जा ही ले लीजिए, जैसे पिज्जा ऑर्डर किया आपने और किसी के पास चला गया, उसने खा लिया, ठीक है। सो here that was not a gratuitous act, so person and enjoying benefit of non-gratuitous act, ठीक है, he is liable to compensate, ठीक है। तो restore करो या compensate करो, if it is restorable restore it, ठीक है। यहाँ पे बोला है or to restore the things so done or delivered, ठीक है। उसको आप रेस्टोर कर दो, नहीं कर सकते रेस्टोर तो उसको कॉम्पेंसेट करो, इट इज कॉल्ड एज क्वांटम मेरिट, ठीक है, ये नाम है इसका। तो इसके एग्जांपल्स, ए ट्रेड्समैन लीव्स गुड्स एट बीज हाउस बाय मिस्टेक, सो ये एग्जांपल जो मैंने बताया था आपको, ठीक है। बी ट्रीट्स द गुड्स एज हिज ओन, इज बाउंड टू पे ए फॉर देम, फाइन। द नेक्स्ट इज ए सेव्स बीज प्रॉपर्टी फ्रॉम फायर, ठीक है। ए सेव्स बीज प्रॉपर्टी फ्रॉम फायर. Now, A is not entitled to compensation if the circumstances show that he intended to act gratuitously. अगर circumstance ये बताता है कि उसने कुछ उससे पैसे मिलेंगे ये सोच के नहीं किया, he basically works for an NGO or something which extinguish fire, ठीक है। On based on that he extinguished, ठीक है, then he cannot ask for any compensation. ठीक है. Now next is responsibility of finder of goods. Okay, a person who finds the goods belonging to another and takes them into custody is subject to the same responsibility as bailey. Okay, law of bailment हम पढ़ेंगे, आज नहीं कल पढ़ेंगे हम, ठीक है. So tomorrow, in tomorrow's class we will have law of bailment, which has bailey and bailer. ठीक है. Bailey is something कि if you have the goods of someone else, जैसे if you have given your bike for servicing, then the person who is servicing, he is your bailey. It's his responsibility to take care of your bike till you take it back. Okay. So responsibility of finder of goods, person who finds goods belonging to another and takes them in his custody is subject to the same responsibility as bailey. ठीक है. Okay. And liability of person to whom money is paid or thing delivered, liability of person to whom money is paid or thing delivered by mistake or under coercion, he must repay or return it. ठीक है, ये तो मालूम ही हम. Okay, so यहाँ पे there is one example. Okay, a railway company refuses to deliver up certain goods to the consignee. Okay, except for payment of illegal charge of carriage. So railway बोल रहा है कि we will not give you goods, but you have to give this much extra. ठीक है ना. consignee pays it क्योंकि he wants his goods, so he paid it at that point of time, but he is entitled to recover that extra charge. ठीक है. चलिए, ये हो गया हमारा क्वेजाई कॉन्ट्रैक्ट. सो नेक्स्ट इज कंटिंजेंट कॉन्ट्रैक्ट. इनकी जोड़ी है क्वेजाई कॉन्ट्रैक्ट एंड कंटिंजेंट कॉन्ट्रैक्ट, सारा पैर. ओके, तो इसमें से हमेशा आपको एक तो आता ही है दोनों में से. ओके, देयर इज एटलीस्ट वन क्वेश्चन फ्रॉम द टू. ठीक है. नेक्स्ट इज कंटिंजेंट कॉन्ट्रैक्ट. ठीक है. So what is contingent contract? The contract to do or not to do something if some event collateral to the contract does or does not happen. यानी ये कैसे है कि ठीक है, contract to do or not to do something if some event does or does not happen. यानी जो आपका ये आप बोल सकते हैं कि अगर बारिश आ गई, ओके, you say if so you are making a contract that if it rains, if it starts raining from the 1st of June, ठीक है, and then I will give you 100 umbrellas, ठीक है, at a price of let me say at a price of rupees 80. ठीक है. But if it doesn't rain till 1st of June, ठीक है, if it rains let me say after 15th of June, ठीक है, तब मैं आपको ये दूंगा 100 रुपए के हिसाब से. Then I will give you for 100. ठीक है. तो this is a contingent contract to do or not to do something based on an event which happens or does not happen. ठीक है, इसको बोलते हैं contingent contract. So example, A contracts to pay B rupees 10,000 if B's house is burnt. ठीक है. आपका बेस्ट एग्जांपल ऑफ कंटिंजेंट कॉन्ट्रैक्ट विल बी इंश्योरेंस कॉन्ट्रैक्ट्स. ठीक है, जैसे ये देखिए यहाँ A contracts to pay B rupees 10,000 if B's house is burnt. It is like an insurance contract, correct? This is a contingent contract. Essentials of a contingent contract: uncertainty and futurity of the event. ठीक है, कुछ फ्यूचर इवेंट है जो आपके हाथ में नहीं है, राइट? Whether it is rains or whether the house will be burnt or not, anything, it's futurity. It's future and uncertain. Okay, so uncertainty and futurity of the event to which it is related. Uncertain future event must be collateral to the contract. उसका कुछ relation होना चाहिए आपके contracts. Okay, that uncertain event must have some relation to the contract. These are the essentials of a contingent contract. यहाँ पे दो केस लॉज है. where it was decided in the first one, it was decided that agreement to sell unspecified half share in the property is not contingent contract. ठीक है, यानी अगर आपने ये ऐसा जो कॉन्ट्रैक्ट है, okay, if you have said that I will sell my 1/4 share in the plot to you. So there are four brothers, right? So you do not know which 1/4 is your share. Okay, you know the total, you know 1/4 is your share. So if you have made a contract to sell unspecified half share, it is not contingent contract. Okay? It's not a contract which depends on a contingent condition. है ना? वो it is not contingent contract that was decided in this case. Harbaksh Singh Gill versus Ram Ratan. Another case is इसमें डिसाइड किया था एग्रीमेंट टू सेल अ हाउस इज नॉट कंटिंजेंट कॉन्ट्रैक्ट. ठीक है, जस्ट टू केस लॉस. नेक्स्ट इज रेसिप्रोकल. ठीक है, रेसिप्रोकल प्रोमिसेस आर नॉट कंटिंजेंट कॉन्ट्रैक्ट्स. ठीक है, रेसिप्रोकल प्रॉमिस इज अ नॉर्मल थिंग इन अ कॉन्ट्रैक्ट. ठीक है, मैं ये करूंगा आप ये करोगे, ऐसा करके बोथ पीपल, दैट इज द नॉर्मल प्रेमिस ऑफ अ कॉन्ट्रैक्ट. कंटिंजेंट कॉन्ट्रैक्ट इज समथिंग, उसमें कंडीशन रहेगा जो हो भी सकता है नहीं भी हो सकता है, दैट्स नॉट इन योर कंट्रोल. ओके, सो रेसिप्रोकल प्रोमिसेस आर नॉट कंटिंजेंट. enforcement of a contingent contract only after contingent event has happened. Okay, तो event है contingent event, वो होने के बाद में आगे का बात होगा. Correct, in both 2-3 examples whatever we have seen so far, right? Only after the event happens further thing can happen, right? The contingency must be distinguished from mere futurity. ठीक है, कुछ चीजें फ्यूचरिटी का मतलब है कि जो फ्यूचर में होगा आपको मालूम है, आज नहीं है बट इन फ्यूचर इट विल हैपन. ठीक है, दैट इज फ्यूचरिटी. कंटिंजेंसी मींस इट मे और मे नॉट हैपन. ठीक है, फाइन. obligation is not conditional before its performance is not yet due. Sorry, obligation is not conditional because its performance is not yet due. ठीक है, अभी तक नहीं हुआ है, अभी तक नहीं हुआ है तो उसको आप कंडीशनल नहीं मानते. सब कोर्ट्स हैव डिसाइडेड दिस. ओके, कि क्या कंटिंजेंसी है. कई केसेस आए that it's a contingent contract, so it was decided whether it is contingent or not. तो ये सब वो चीजें हैं. ठीक है, तो obligation is not conditional just because the performance is not yet due. performance future में होना है, that doesn't mean it is contingent. okay, contingent contract need not necessarily be dependent on any external event. ठीक है, कंटिंजेंट इवेंट जो है वो हमारे अंदर का भी हो सकता है. इट डजेंट मीन कि हम लोग बात कर रहे हैं और किसी चीज के ऊपर ही आप कंटिंजेंट करें. हो सकता है आपके लाइफ का कोई चीज हो, दैट कैन ऑल्सो बी अ कंटिंजेंट कॉन्ट्रैक्ट. ओके, सो कंडीशन कैन बी आर कंडीशन, इट कैन बी सम आउटसाइड कंडीशन, दैट्स नॉट अ प्रॉब्लम. ठीक है, it may be conditional on the voluntary act or future conduct or one or more one of the parties or third person. ठीक है, कोई some it can also be कि फ्यूचर में किसी और का कंडक्ट के ऊपर. ठीक है, कि जैसे अगर इसने इससे शादी कर लिया तो मैं तेको इतने पैसे दूंगा, समथिंग लाइक दैट. ओके, so future conduct, it can be about future conduct of someone else, it can be about your own future conduct also. ठीक है, right? Enforcement of contingent contract cannot be enforced by law unless and until that event has happened. ठीक है, contingent contract to be enforced, that event, contingent event must happen. Okay, if it becomes impossible, contract becomes void. Okay? Contract will happen only when contingent event has happened. If that event has become impossible, it is not going to happen, so contract becomes void. Okay, एक example देखेंगे. A makes a contract with B to buy B's horse if A survives C. ठीक है, A makes a contract with B to buy B's horse. ठीक है, if A survives C, A survives C यानी A survives C. जब आप देखे होंगे इन ओबिचुअरीज जब लोग किसी का डेथ होता है वहां पे लिखते हैं ना, ये पास्ड अवे, ही इज सर्वाइव्ड बाय हिज सन वाइफ, ये सब ऐसा आता है, राइट? सो सर्वाइव मीन्स द पर्सन हु हैज आउटलिव्ड द अदर पर्सन. So if A survives C means A should outlive C. ठीक है? So A makes a contract with B to buy B's horse. I will buy your horse if you survive C. That is, if C dies before you. So when C dies, only then the contract will get applicable. Okay, will become applicable. This contract cannot be enforced in law unless and until C dies in A's lifetime. ठीक है? तो ए सर्वाइव सी कंडीशन है. ये सर्वाइव कब होगा? जब सी मर जाएगा तभी ना. ए से पहले सी मरेगा तभी ये कंडीशन फुलफिल होगा. ए सर्वाइव सी. ओके, ठीक है ना? चलिए. ओके, सो कॉन्ट्रैक्ट कैन नॉट बी एनफोर्स्ड इन लॉ अनलेस एंड अनटिल सी डाइज इन एज लाइफ टाइम. चलिए, नेक्स्ट इज एनफोर्समेंट ऑफ कॉन्ट्रैक्ट्स कंटिंजेंट ऑन एन इवेंट नॉट हैपनिंग. ठीक है? अब कंटिजेंसी में कई चीजें, दो तीन टाइप होते हैं. एक है कि इफ दिस थिंग विल हैपन ऑन दिस डेट देन वी विल डू दिस, ये हो गया पॉजिटिव. दूसरा हो गया इफ दिस विल नॉट हैपन, पॉजिटिव एंड नेगेटिव यू कैन गो, राइट? सो एनफोर्समेंट ऑफ कॉन्ट्रैक्ट्स कंटिंजेंट ऑन एन इवेंट नॉट हैपनिंग. ठीक है? इट कैन बी एनफोर्स्ड व्हेन द हैपनिंग ऑफ दैट इवेंट बिकम्स इम्पॉसिबल. ठीक है? अगर यू आर डिफाइनिंग एन इवेंट, if this does not happen then we will have a contract, बोल रहे हैं. So does not happen यानी कल भी हो सकता है, परसों भी हो सकता है, राइट? 5 साल बाद भी हो सकता है, 10 साल बाद भी हो सकता है, राइट? So if you want to have a contract, if an event does not happen, it will happen when that event becomes impossible. When it becomes impossible, you can say that now it will not happen, right? So can be enforced when the happening of that event becomes impossible and not before. ठीक है? Okay. A agrees to pay B a sum of money if a certain ship does not return. ठीक है? Now does not, जब ये negative condition का condition होगा, so the ship is sunk, then the contract can be enforced. Okay? ठीक है? Deemed impossible contract. ठीक है? कुछ चीजें deemed की, जब यहाँ पे ये real impossible contract, ship has sunk, contract cannot happen, real impossible. Now deemed impossible कब बोलते हैं? ठीक है? I'll explain. Okay? If the future event on which the contract is contingent is the way in which a person will act at an unspecified time, event becomes impossible when that person does something to render it impossible. Okay? That he should so act within any definite time or otherwise than any further contingencies. ठीक है? ये एक बहुत कॉम्प्लेक्स सेंटेंस है, मैं आपको इसका मतलब समझाता हूँ. ठीक है? सो यू कैन राइट बेस्ड ऑन दैट. ओके, द सेंटेंस इज वेरी कॉम्प्लेक्स, विल नॉट बी एबल टू लर्न इट ऑल्सो. ठीक है? इसका मतलब ये है. ओके, सब डीम्ड इम्पॉसिबल यानी कुछ चीजें हैं जो विच डजंट बिकम टोटली इम्पॉसिबल. ठीक है? बट इट we consider that okay, it is more or less impossible. Example. ठीक है? We'll take an example. A agrees to pay B a sum of money if B marries C. ठीक है? A agrees to pay B a sum of money. ठीक है? अगर B marries C, लेकिन C ने और किसी से शादी कर लिया. ठीक है? C has married someone else. The marriage to B to C will now be considered impossible. Correct? Although it is possible that D may die and C may afterwards marry B. ठीक है? D मर भी सकता है और ये भी हो सकता है they can be divorced. ठीक है? डिवोर्स भी हो गया तो then it's a chance, right, कि B, C ने D से मैरिज कर लिया. इसका ये मतलब है कि C जिंदगी में और कोई मैरिज करेगा ही नहीं करके. Does it mean that C will not marry anyone else? ऐसा नहीं है, right? But from a human point of view, we say that okay, now if C has married D, so हम भी consider it as impossible. ठीक है, so इसीलिए इसको impossible नहीं बोल रहे, इसको बोल रहे हैं deemed impossible. Okay, so condition was if B marries C, he will give him some money. But C has married D, so this contract is gone. Now, that is another case. After 5 years, these two have divorced, and now C is again an unmarried person. ठीक है, वो दूसरी बात होगी. But this contract will come to an end here. At the moment, C married D. Clear? Okay. Next is happening of a specified event within fixed time. Happening of a specified event within fixed time. ठीक है, अब ये जो है ऐसे 2-3 कंडीशन के हिसाब से you can have contingent contracts. One was the negative one. Second is you are saying happening of an event within fixed time. You are giving a time. इतने टाइम में हो गया तो कॉन्ट्रैक्ट करेंगे. ठीक है, इतने टाइम में नहीं हुआ तो देन नो कॉन्ट्रैक्ट. ओके, within this time you can have a contract. So within a fixed time, it becomes void if at the expiration of the time fixed, such event has not happened. It becomes void if at the expiration of the time fixed, ठीक है, such event does not happen. तो उतने टाइम में ओके, क्योंकि जैसे अभी ये मैरिज का इसमें सब जैसे हम लोग मूवीज वगैरह में देखते हैं, राइट? तो व्हाट, सो अभी जैसे ठीक है, हीरोइन के डैड वगैरह क्या बोलते हैं, ठीक है, आप कुछ बन के दिखाओ 1 साल में, नहीं तो मैं मेरी बेटी की शादी और कहीं कर दूंगा. ठीक है, तो दे गिव अ टाइम, राइट? तो हम इसकी बात यहाँ पे कर रहे हैं. If it becomes void at the expiration of the time fixed, ठीक है, if within 1 year he doesn't accomplish his target, ठीक है, तो contract becomes void. Fine. Such event has not happened, or if before the time fixed it becomes impossible. ठीक है, कभी कभी ये भी होता है कि before the time fixed it will become impossible. ठीक है, यही एग्जांपल लेंगे जो मैंने बोला कि हीरोइन के फादर ने बोला आप 1 साल में कुछ बन के दिखाओ. ठीक है, 1 साल में नहीं बना कुछ हीरो तो वॉइड कॉन्ट्रैक्ट. ठीक है, और अगर 6 महीने में मर गया हीरो तो भी वॉइड. करेक्ट? सो दिस इज इफ इट बिकम्स इम्पॉसिबल, देन ऑल्सो इट इज वॉइड. ओके, स्पेसिफाइड अनसर्टेन इवेंट डज नॉट हैपन विद इन अ फिक्स्ड टाइम. नेक्स्ट क्या है? स्पेसिफाइड अनसर्टेन इवेंट, ओके, डज नॉट हैपन विद इन अ फिक्स्ड टाइम. ये जो है इसमें हम क्या बोल रहे हैं, इसका बस एक और ऑब्जर्वेशन दे रहे हैं. ठीक है, इसमें जस्ट एन ऑब्जर्वेशन. It may be enforced by law when the time fixed has expired and such event has not happened, or before the time fixed has expired, okay, it becomes certain that such event will not happen. पता चल गया कि ये नहीं होगा. तो ये जो है कि ऊपर में जो हमने पढ़े हैं ना, happening of a specified event, ठीक है, within a fixed time, इसका इसमें जो ट्रीटमेंट आपने किया सेम ट्रीटमेंट है यहाँ पे भी. ठीक है, ओके, यहाँ पे इवेंट फिक्स्ड है. ठीक है, जैसे मैरिज, यानी आप मैरिज की बात कर रहे हो, फिक्स्ड है. यहाँ पे इट इज सम अनसर्टेन इवेंट. ठीक है, और ओके, इट उसका जो होना नहीं होना, इट डज नॉट हैपन विद इन अ फिक्स्ड टाइम. सो इसको ये जस्ट इसका एक वेरिएंट है. आप अगर देखोगे क्लोजली, सो बोथ गिव टू राइज टू द सेम सॉल्यूशन. ठीक है, हैपनिंग विद इन फिक्स्ड टाइम है, ये भी विद इन फिक्स्ड टाइम है. ठीक है, this is a specified event. Okay, it is some uncertain event. Okay, any uncertain event. बस उतना ही. तो दोनों का सेम ट्रीटमेंट है बिल्कुल. ओके, सो वी विल सी एग्जांपल देखेंगे तो आप क्लियर हो जाएगा. 2 एग्जांपल्स में इट विल बी क्लियर. ओके, सो बोथ विल लुक वेरी अलाइक. ठीक है, दोनों सेम दिखेंगे हमको. A promises to pay B a sum of money if a certain ship returns within a year. ठीक है, if a certain ship returns within a year, contract can be enforced if the ship returns within the year and becomes void if the ship is burnt within the year. ठीक है. और next is A promises to pay B a sum of money if a certain ship does not return within a year. ठीक है. यहाँ पे हमने same example है. Here we said it returns within a year. ठीक है. Here we said returns within a year. Here we are saying does not return within a year. ठीक है. Okay. So if it does not return within a year के ऊपर हमने contract किया है negative. Okay. So it may be enforced if the ship does not return. Okay. Or it is burnt. If it is burnt, then it will not return. ठीक है. तो दोनों केस में कंडीशन फुलफिल होता है. So it's just two main ways of phrasing your contingent contracts, positive and negative. ठीक है. इसी के ऊपर पूरा बेस्ड है. Fine. Now next is an agreement contingent on impossible event. Agreement contingent on impossible event is void. ठीक है. यानी इवेंट ही इम्पॉसिबल है, उसके ऊपर आपने कंटिंजेंट किया है, so it will become void. Okay. So here contingent agreements to do or not to do anything if an impossible event happens are void, whether the impossibility is known or not to the parties at the time of agreement. ठीक है. It's not essential that you should know about the impossibility. ठीक है. आपको मालूम हो ना हो, still impossible event है तो it will become void. ठीक है. दोनों में से एक पार्टी को अगर इवन मालूम भी था कि दैट्स एन इम्पॉसिबल इवेंट, को भी कोई प्रॉब्लम नहीं है. ठीक है. राइट. तो इसमें 2 एग्जांपल्स, उसके बाद this part will be over. Okay. A agrees to pay 1,000 if 2 straight lines should enclose a space. This agreement is void. ठीक है. ये एक ज्योमेट्री का चीज लिया है, तो ऐसा तो नहीं पूछेगा. ये एक याद रख लेना. ओके. The agreement is void. Reason being 2 straight lines जो है ना, स्पेस के लिए 4 लाइन चाहिए. ठीक है. और स्पेस, दिस इज 1 लाइन, दिस इज 2 लाइन. ठीक है. लाइन इज दोनों तरफ से चल आगे जाता है. राइट. ठीक है. ये आगे जाते जाएगा, दिस विल गो ऑन. ये सब जो है, ठीक है, लाइन है ना. सो यानी ऐसे बनाता हूँ. ठीक है. दिस इज 1 स्ट्रेट लाइन, दिस इज 2 स्ट्रेट लाइन. ठीक है. 2 स्ट्रेट लाइन कैन डज नॉट एनक्लोज अ स्पेस. इसमें आपको और 2 स्ट्रेट लाइन चाहिए, तब ये जो आपका जो बीच का जो पार्ट है ना, दिस इज अ स्पेस. इसलिए ये खैर जो ज्योमेट्री का ये है, ये आपको आपसे ये एक्सपेक्टेशन नहीं रखेगा कोई कि आपको मालूम है कि नहीं कि कितने स्ट्रेट लाइन स्पेस बनाते हैं. राइट. इट इज जस्ट एन एग्जांपल. तो बस ये है कि याद रख लेना, क्योंकि इट इज गिवन एज एग्जांपल. सो ठीक है, क्योंकि ये इम्पॉसिबल इवेंट, इट विल नेवर हैपन, सो इट इज वॉइड. ए एग्रीज टू पे बी 1,000 if B will marry A's daughter. ठीक है. A agrees to pay B 1,000 if B marries A's daughter. ठीक है. उसके डॉटर. अब C जो है उसकी डॉटर, शी वॉज डेड एट द टाइम ऑफ एग्रीमेंट, उनको मालूम नहीं था. एग्रीमेंट बिकम्स वॉइड. ठीक है. ये सब हो गया. नेक्स्ट इज डिस्चार्ज ऑफ कॉन्ट्रैक्ट. ठीक है. ये हम कंटिन्यू करेंगे थोड़ी देर में. ओके. I'll just give you a 5-minute break. ठीक है. So 8:45. ठीक है. तो ये टॉपिक फुल्ली वी माइट नॉट बी एबल टू कंप्लीट. ठीक है. जितना भी होता है वो करेंगे. ठीक है. and we'll continue tomorrow. Okay. So we'll come back at 8:45. We will go on for 15 or 20 minutes. ठीक है. चलिए. Fine. Okay, so welcome back. We will continue maybe our last 15 to 18 minutes. Okay. So next thing is discharge of contracts. Okay. When a contract is completed, okay, normally it is called as contract is discharged. But sometimes contract, if say both parties decide that we don't want to perform the contract, that way also it can be discharged. The common ways contract will be performed, payment will be done, it will be discharged. That is the common way. So let us see what are the various ways of discharge of contracts. So the rights and obligations created by a contract come to an end. Okay, contract is said to be discharged or terminated. Okay. So when rights and obligations created by contract come to an end. So now no one needs to perform the contract. Okay. That then it is called as contract is discharged or terminated. Fine. So in other words, discharge of contract means termination of contractual relationship. Okay. Discharge means termination of contractual relationship between the parties. Okay. So let us see what are the modes of discharge of contracts. What are the various ways you can discharge contracts? Okay. Discharge amounts to end of the contract. Fine. So you can have discharge by performance, that you have done your part of the contract, the other party has done his part of the contract. Okay. Discharged by performance, discharged by agreement. Okay. We'll see each of these. We'll discuss each of these. Next is discharge by lapse of time, by operation of law, by impossibility of performance, okay, and by breach of contract. These are the ways, 6 ways of discharge of contract. Okay. So let's see the first one. What is the first one? Discharge by performance. Okay. So discharge by performance. It is the usual mode of discharge. Normally, see, most 90% contracts, why contracts are formed? To perform it, correct? So they are performed, payment is made, and it is discharged. It is the usual mode of discharge. Okay. Discharge may be by, okay, actual performance, attempted performance. Okay. There are 2 ways of discharge by performance, by actual and attempted performance. Actual performance is what we all know. When we have performed the contract and payment has been made, that is actual performance. Okay. So actual performance is fulfillment of the obligations by the parties in accordance with the contract. Okay. So that is your actual performance. So now for attempted performance, offer of performance is also known as attempted performance or tender of performance. Okay. Valid tender of performance is equivalent to performance. This means if you are saying after you have signed your contract, okay, and say after a while, if the person checks with you whether you're going to do the contract or not, you are saying, yeah, I'll do. It will require another 6 months, whatever the duration, another 6 months, but I am doing it. Okay. So this is called you have given a valid tender. So till the time you have, whatever time you have given within your framework, okay, till that time, nobody will say that you have not performed the contract. Okay. Nobody will say that you have not performed the contract this time. So a valid tender of performance is equivalent to performance. If after tender you did not perform later on, after that time is over, okay, then only it will be a breach. So, which is why discharge by performance are of 2 types: actual performance and attempted performance. Okay. So this again is the flow chart for modes of discharge. Okay. So again, we will, after finishing discharge, I will bring you back, okay, to this flow chart. Fine. So second is discharge by agreement. Okay. So here discharge is happening because of an agreement. Here obviously the contract is not completed, which is why parties are agreeing to terminate the contract. Okay. There are 5 ways of doing it: novation, alteration, rescission, remission, and waiver. Okay. These are discharge by agreement 5 ways: novation, alteration, rescission, remission, waiver. Okay, so novation of contract means, okay, you are substituting a new contract in place of existing contract. Okay, so it discharges the original contract. So I've seen that old contract has many loopholes. So you have both decided that, okay, let's discharge the old contract, will form a fresh contract. That is called as novation. Okay, the new contract replaces the old contract. So new contract may be between the same parties or between different parties. Okay, you can also say that, say for example, uh, there is this another party and you, contract was between you. So now say you are not able to do it, so you are telling him that my brother will do it. Okay, you have a contract with my brother, he will do it. Okay, I guarantee he'll do properly. So then what you did is, here this party, this contract is cancelled, and now this party has a contract with your brother. That's also possible. So okay, so here what happens is, the new contract can be between the same parties or between different parties also. Okay, so this is novation of contract. Okay, so novation can take place only with the consent of all the parties. There has to be consent of all parties involved. Here is an example. A owes money to B under a contract. Is okay. A owes money to B under a contract. It is agreed between A, B, and C, okay, that B should accept C as his debtor. Okay, so leave the current debtor, in his place take another person as his debtor instead of A. Okay, old debt of A and B is at an end, and a new debt from C to B has been contracted. Okay, this is similar to example which I gave you, right? So this is called novation involving change of parties. Novation can involve change of parties, might be between the same parties. So this is novation. So second is alteration. Okay, B is alteration. Alteration means change in one or more terms of the contract. Okay, contract, it is change of terms. Okay, in novation there can be a change in parties. In alteration, parties are always same. Okay, parties are always same. Only change in terms happens. Okay, there's only change in terms. The next is rescission. Okay, rescission is cancellation of contract. Okay, all or some of the terms may be cancelled. Full terms or some terms is cancelled. Okay, it results in discharge of the contract. New contract comes into picture. A promises to deliver certain goods to B at a certain date. Before the date of performance, A and B mutually agree that the contract need not be performed. Okay, so they thought that now the contract need not be performed. So contract is discharged by rescission. Say for example, where in some cases tsunamis and all happen, when tsunami would have happened, okay, just one day before there would have been many contracts, correct, to be performed on the day of the tsunami, correct, right? But when tsunami happened, then they would have had to rescind all contracts, correct? It was not possible to perform, isn't it? So this is rescission, which is cancellation. Okay, cancellation of contract. Then you have what? Remission. Okay, next is remission. This was rescission, which is cancellation. Remission. Remission is acceptance of a lesser performance. Okay, so you see an example here. There is no need for consideration for remission. Okay, A has borrowed 500 rupees from B. He agrees to accept 250 in satisfaction of the debt. Whole debt is discharged. So sometimes what happens, see, you have to take 5,000 from someone. Okay, so he is not under great financial condition. He's saying, I'll give you 3,500. Okay, if you go to a court, so now what is your loss? 1,500, correct? If you go to a court, then you might have to pay another 5,000 to an advocate and all that. So that is more costly. So you would say that, okay, you give me 3,500, I will discharge the contract. Okay, so acceptance of a lesser performance. Okay, okay. Or many times it happens that you give contracts for whitewash and all that, and say that person has met with an accident. Okay, then you say that okay, I will cancel the contract. Okay, if you see that like he's not in a position to pay, so you can say that in real life you find situations where you accept a lesser performance. Okay, you will say that okay, whatever is done, okay, that much is fine, I will relieve you. Okay, so then after this, next is waiver. Waiver is giving up or foregoing certain rights. Okay, waiving is you are uh, normally this word is used a lot, right? You waive off the rights. Okay, when an party agrees to gives up his rights, contract is discharged. You give up your rights fully. Okay, A promises to paint a picture of B. B afterwards forbids him from do so. Okay, now no need. He said A did something for B. Then he said, okay, in return I will paint a picture. Okay, and later on, say he was sick or whatever, then A said, okay, you don't need to. I release you fully. So in waiver, you will release him fully. Okay, and in remission, okay, you will accept a lesser performance. Okay, fine. So these are, just a moment. Okay, so this is discharge by agreement, and first one by performance. Okay, so, okay, so these are the modes of discharge of contract. So we have done discharge by performance. Okay, and we have done discharge by agreement. Okay, for agreement we had these 5 points. If I show you this flow chart now, see what we have seen is, okay, discharge by performance, actual performance and attempted performance. Discharge by agreement, novation, alteration, rescission, remission, waiver. Okay, now we are going to do the third one, discharge by lapse of time. Okay, okay, this is discharge by lapse of time. So every every contract must be performed within a fixed or reasonable period. Correct. Lapse of time discharges the contract. So for example, here Indian Limitation Act has prescribed period within which existing rights can be enforced in a court of law. So the Limitation Act, law of limitation, which I told you earlier, correct? So Limitation Act is something which says that for any uh, say if anyone has not performed anything, so you have a right to go to court, right? If you have a right to go to court, right to sue, there is a limitation period for this always. Okay, so beyond that you cannot go. It can be 3 years, some cases 5 years, like that. Okay, the law defines for various types of contracts the law of limitation. Okay, so beyond this you cannot, your remedy goes off. Okay, within this period you will have to sue. Okay, if you want to. So okay, Indian Limitation Act prescribes the period within which the existing rights can be enforced in a court of law. If a creditor does not file suit within 3 years of debt, the debt becomes time barred. It's called as time barred. Okay, he's deprived of his legal remedy. Okay, discharge by lapse of time talks more of time barred debts. Okay, the next is discharge by operation of law. Okay, it is discharged by operation of law many times. How? By death, insolvency, unauthorized material alteration, and merger. Okay, four points of discharge by operation of law. So if someone dies, so what happens is for contracts involving personal skill or ability, death terminates the contract because his legal heirs will not be able to do it. Okay, only he has that skill. If there is a painter, doesn't mean his son will be as good a painter as he is. Okay, contracts involving personal skill or liability, death terminates contracts. In other words, rights and liabilities of the deceased person will passed on. In other cases, it will be passed on to legal representatives. Okay. Other cases, normal cases, rights and liabilities will be passed on to his legal representatives. Now, second is insolvency. Insolvency of the promisor discharges the contract. Promisor is discharged from all liabilities incurred prior to his adjudication. Okay. Insolvency discharges the contract because now he has no money with him. He is at zero. Okay. So this is insolvency. Third is unauthorized material alteration. So if you without telling the other party have made some material alteration, then it discharges the contract. Okay. The change here example is change in the amount of money to be paid, date of payment, place of payment. This all comes under material alteration. If you do this without telling the other party, contract gets discharged. Okay. Merger. Merger means when inferior rights under a contract merge with superior rights under a new contract. Okay, inferior rights will come to an end. So here best example is whenever you get promotions, part-time lecturer is made full-time lecturer. It's called as merger, and part-time rights, whatever he was getting, automatically gets cancelled. You don't have to separately go and cancel it. Now only the new full-time lecturer, whatever offer is there, that will be there. Okay, so that's called as merger. So when you get superior rights, so inferior rights will get discharged automatically. Fine. Then discharge by impossibility of performance. Okay. If there is impossibility of performance, contract will be discharged automatically. Agreement which is impossible is void because law does not compel you to do, okay, impossible things. Now, discharge by breach. This is the last point. Discharge by breach of contract. Okay. Here, breach means failure of a party to perform his obligations. It ends the contract. Okay. Now, A and B wanted to marry each other before the time fixed for marriage. A goes mad. Okay. Contract becomes void. Okay. If breach happens, contract is discharged. Okay. But there can be some penalty clauses with breach. Okay. But that contract comes to an end. Right. So, okay. So here, this is one last sentence, para, which we'll have to finish. So here, termination of a contract. So you have to give a notice. This is a special case actually, where it was said that for terminating a contract, you have to give notice and termination. It is not general, it is for specific thing. Okay. Issue of notice to the plaintiff calling upon to complete the transaction within particular time. Okay. So failing which the contract will be treated as cancelled. Okay. So here what has been told is, okay, before you treat the contract as cancelled, okay, before you treat the contract as cancelled, you will have to issue notice to the plaintiff. Okay. So you have to issue a notice. This is only for certain things, as I said. Okay. It is for real estate things only. Okay. So in Narayan Swamy Pillai versus Dhanakodi Ammal held that when the contract is for sale of movable property, the vendor must give reasonable notice requiring the performance within a definite time. Okay, held that when the contract is for the sale of immovable property, vendor must give a reasonable notice requiring the performance. Here, the thing what has happened is the lady here Okay, the lady was to give him his land. Okay, so she did not give. So what was told by lawyers, before you cancel the contract, give her a notice first, asking her to pay. This is just a special case. Okay, notice has to be given, and this is in relation to a real estate transaction. Okay, fine. So that's it. We'll complete now, and okay, we'll continue tomorrow. Fine. So I think tomorrow and maybe uh, I think probably 2 more lectures might be needed to complete it. Okay. And thank you.